Good morning, everyone. I'll call the meeting to order on behalf of Senate Co-Chairman Tara Nethercott and myself, Representative Dan Kirkbride. We welcome you to the Interim Joint Judiciary Committee meeting. The first of three we'll be holding between now and November. So I'd ask the Secretary to please call the roll of members.
Senator Anselmi Dalton.
Present.
Senator Brian Boner.
Excused.
Senator Cost.
Present.
Senator Von Flater.
Here.
Representative Burlingame.
Here.
Representative Gray.
Here.
Representative Jennings.
Here.
Representative Pelkey.
Here.
Representative Pawnell.
Here.
Representative Salazar.
Here.
Representative Stith.
Here.
Representative Washut.
Here.
Co-Chairman Nethercott.
Here.
Co-Chairman Kirkbride.
Here. Thank you. I have a few housekeeping announcements for the committee members themselves, and then we'll get going with our meeting. Committee members, I'd ask that we use convention to alphabetize ourselves over in the participants box on the right side of your screen. Use Representative Burlingame's name and title as a model, if you would. And senators, if you would do SIN, period, space, cost, and so forth. And LSO, I believe, is all nicely lined up. So that was very helpful over the weekend when we had everybody using the same system. So again, Representative Burlingame is the model for how to do that. We've already had our roll call by voice vote. When we vote today, should we vote, we'll use the hands in front of the face system. If you have questions that you want to ask the witnesses as time moves on, would you please raise your blue hand? Or if you have a point of order, you might want to raise your blue hand. I see that Senator Anselmi Dalton has hers raised right now. Senator Anselmi Dalton.
Thank you, Mr. Chairman. I just wanted to say that maybe we should wish Representative Stith a happy birthday.
Happy birthday, Mr. Vice Chairman, Representative Stith.
Mr. Chairman,
Happy birthday.
thank you. I'm trying to figure out how to virtually touch up my appearance. I'm feeling older today.
Well, could you have figured a better way to spend your birthday than to spend it with us?
Not at all.
Okay, committee, remember that typically at this first meeting, where we're headed at the end of these topics is perhaps a motion for LSO to draft a bill on the topic. That's where we'd like to get to at the end of our deliberations today. If anybody gets knocked off their video and needs tech help, call LSO and ask for Jamie or Dave. We're going to have our internal chat box open so you can talk to one another that way. Do remember that your chat will be visible to the other witnesses in the room. So when we invite our expert witnesses into the room, they'll all be able to see what you're doing unless you use the private one-to-one chat. And then that indeed will be private. So folks, if you're listening on YouTube, you joined us and we're all meeting virtually from our homes and offices all around the state. But the legislature had good success meeting over the weekend in this special session using this technology. So I think it'll work well today. We'll try to run a good ship. I want to introduce our LSO staff that's assisting us these days. We have Brian Fuller, the staff attorney, David Hopkinson, staff attorney, Mary Beth Oatsfall, legislative editor, and Danielle Creech, associate research analyst. So let's begin our discussions. And Mary Beth, if you would admit the witnesses, I believe we have 6 witnesses coming for our first topic. Good morning, folks. Welcome to our meeting. When you get a chance, if you could name yourselves.
Sorry, Jake Fulkerson, Park County Commissioner.
Yes, welcome, Commissioner. Okay, a few instructions for the witnesses as we begin our time together. We'll run this like we would a normal live meeting, in that when it's your turn to speak and I bring you up to the group, if you'd introduce yourself and tell us your position and affiliation, if you have one. If you would direct your comments through the chair as you address the committee, or if you respond to questions just as you would in a live meeting, we appreciate that. Then we're going to ask that the people who are not testifying turn off their camera, so that in a minute when we start with Mr. Riemann, while he's testifying, everyone else would have just their name showing. I see that that's being done, so that'll help the public to focus on who's testifying. All right, we're almost there. Somebody asked me, how much time do we have to speak? And you can all see the agenda and how much time is allotted to the topic and how many witnesses there are. So I think the thing that would do us in the worst would be if somebody went a half hour. That won't work, but you all are all our guests. We've invited you here. These are complicated topics. We know they take some explanation. So I think the watchword of the day for our time together is to be expeditious. And I looked up expeditious. It says acting with prompt efficiency. So we'll proceed with prompt efficiency. Our first topic is a review of salary caps for county and prosecuting attorneys, district attorneys, and sheriffs. And we'll have a topic introduction by the LSO staff.
I think he's on mute.
David,
still.
you're on mute still.
There we go. Sorry for that. Mr. Chairman, David Hopkinson with the Legislative Service Office to introduce this topic. The committee decided to review and discuss the statutory salary caps for county and prosecuting attorneys, district attorneys, and sheriffs. Those salary caps are set by statute. Wyoming statute 183107 sets the salaries for sheriffs and county attorneys and county and prosecuting attorneys. Wyoming statute 91802 sets the salaries for district attorneys. Those were last amended in 2009, with the changes taking effect in 2011. Sheriff and part-time county attorneys and county and prosecuting attorneys essentially are allotted not less than $10,000 nor more than $100,000. So they are capped at $100,000. Full-time county and prosecuting attorneys are allotted not less than $35,000, and they are capped at the same salary as a district attorney, which is set currently at $100,000. For county and prosecuting attorneys, the state does pay half of the salary for those individuals, with the county picking up the rest. And for deputy and assistant county and prosecuting attorneys, the state pays $30,000 or 50%, whichever is less. So that is currently where they are in statute, and I would stand for any questions.
Thank you, Mr. Hopkinson. I see that Senator Anselmi Dalton has her blue hand up. Did you have a question, Senator? Please proceed.
Thank you, Mr. Chairman. I just wanted to let you know that I do not think the group chat is working. So I just wanted to ask that to be enabled.
Okay. We'll ask our staff to attend to that. Representative Pelkey? Or Representative Gray, you're first. Representative Gray?
Thank you, Mr. Chairman. So there was a little bit of a discussion in the materials about the narrative and of the legislative history on how that 50% got there. Could Mr. Hopkinson expand on that a little bit, that 50% share?
Mr. Hopkinson.
I do believe some of the other presenters have more detailed information on that. I think that was, I'm just pulling up some of my documents here. That was an agreement that came about in 2007. I honestly don't know the details of how that came about, though.
Representative Gray?
Thank you.
Representative Pelkey?
Yeah, I was wondering if you could address particularly the district and county attorney salary caps and how long those have been at a maximum of $100,000.
Mr.
Mr.
Hopkinson?
Chairman, those have been set since 2011. They were amended in 2009 with the actual salary cap taking effect in 2011, June of 2011.
Any further questions for Mr. Hopkinson? Okay, committee, I'd ask that you take down your blue hands yourselves when you're done asking our question. I know somebody may have been taking them down on Saturday, but there we go. That's great. Okay, if there's no further questions for Mr. Hopkinson, let's hear from Mr. Riemann of the Wyoming County Commissioners Association.
Good morning, Mr. Chairman, members of the committee. My name is Jeremiah Riemann, and I represent Wyoming's County Commissioners. I will be expeditious in my comments this morning. Today I'm joined by Jake Fulkerson, who's a Park County Commissioner, who will provide a couple of comments after I finish. I certainly do appreciate the committee's attention to this topic. It's certainly an important one. And our legal system is one of the most important elements to our democracy and to our counties. Having qualified and competent and experienced attorneys and sheriffs is critical. As critical is our need to have the ability to retain them in our communities, which can be difficult. And at current, we have one county that does not have an elected county attorney from that county, but rather resides in a neighboring county. So this is certainly part of the heart of that issue. As you evaluate this issue, we would certainly request that you continue to leave that decision on what salary adjustments might be made to the local level where we believe it is best served. Certainly, this is a difficult time to make adjustments, but I believe that the data shows that county commissioners over a period of years have been very judicious. And further, any adjustments that might be made, as were referenced earlier, would not impact those individuals in their current seats during their current term. It does have a lag. And again, we certainly appreciate you looking at this. There are experts that have better information about the specifics of the changes that have been made over time, but commissioners do support this evaluation and look forward to being a part of that process. And with that, Mr. Chairman, I would like to turn it over to Commissioner Jake Fulkerson.
Commissioner Fulkerson.
Mr. Chairman, Madam Co-Chair, and committee, thank you for your time, and I'll be brief. First, I want to apologize for my dress code. I see I'm the only one here without a tie. I certainly didn't mean to offend anybody. If I was down there, I might be different. But as Jeremiah mentioned, the commissioners do support further evaluation of this review of the salary caps for district attorney, county attorney, prosecuting attorneys, and sheriffs. We're running up against the caps in many counties. In Park County, our county attorney will be at 99,000 next year, and we'd appreciate this initial evaluation to provide us some flexibility. Mr. Chairman, that's all I have. And again, thank you for your time. I would like to mention Senator Costa. I like the horses in the background. Thank you.
Committee, any questions for the commissioner representatives? Representative Stith.
Mr. Chairman, thank you. With respect to the salary cap information, I wanted to find out if that includes the contribution that the county makes for the health insurance premiums, and if that includes the contribution that the state makes or the county makes toward the pension fund. And if not, then how much is the actual cap if you add those two things in?
Gentlemen?
Mr. Chairman, Representative Stith, those figures that have been provided, I do not believe include those salaries and benefits that are associated with positions. And of course, those would vary across the various counties in terms of how much of a percentage each county is paying for health insurance, what amount is being contributed to retirement. So I couldn't give you that figure off the top of my head. We certainly could work with counties to provide that information, but no, it's my understanding the data that you've been provided does not include benefits.
Committee, now that we're into this a little, I don't have all your names in the participants box. So there may be blue hands I'm missing. So I think I'll ask you just to raise your hand up by your face, and that'll probably be easier for me to spot you when you do that. And Representative Pennell, you have a question.
Yeah, thank you, Mr. Chairman. My question to Mr. Ryman. Is it my understanding that as a whole, the county commissioners across the state are wanting to increase this cap? And if so, did they have some dollar figure that they were wanting to raise the cap for these, for the county to set? I mean, I know they set the dollar amount, but to what to give a raise, but I'm curious if they have a cap in mind. Thank you.
Mr. Chairman, Representative Pennell, great question. At this point in time, the commissioners have only settled on an agreement that we support this evaluation. We haven't come to a consensus on what that cap should be. You will certainly hear the attorneys and perhaps even the sheriffs provide their perspective on what that should be. I apologize, I'm having some camera difficulties here. We have not come to a consensus on that particular issue. The one thing that we have consensus around is the need for the decision to change those salaries to remain local. And as the data suggests, as I mentioned, commissioners have been rather judicious in making some of those decisions.
Madam Co-Chairman.
Thank you, Mr. Co-Chair. Good morning, Mr. Riemann. How long will it take the county commissioners to come to a consensus as to the proposal by Ms. Weissman, as you are aware of, to set that cap to be consistent with the district court judges' salaries? But even though that's the maximum salary cap, they're not suggesting that that's be what the salary is, but still allows that full discretion to those counties with a maximum salary cap as a protective measure. Seems like a pretty straightforward request. Tell me why there's not a consensus yet, when you expect a consensus to come, and what some of the concerns that have been discussed or are being discussed may be.
Mr. Riemann.
Mr. Chairman, Co-Chair Nethercott, a great question. The commissioners will be meeting as a board next month. All things considering, and at that point in time, I would expect that we'll be able to discuss this further and come to some sort of a consensus on what that number should be. And it may be adoption of the proposal that's before you today. In terms of the discussion that's happened so far, that has been limited in some regards, given that we're getting this information about proposals as you are. But some of the concerns that I've heard are certainly what other officials' salaries might look like in a particular community or in other areas of law. For example, and I think I shared this with you at one point in time, consideration of Attorney General's office salaries and some of the salary tables that exist there and the caps that are associated with that. So all of that will certainly be considered, and I would expect we'd be able to provide you with a more firm answer at the end of next month.
Madam Co-Chairman.
Thank you, Mr. Co-Chairman. Just as a point that I thought would be a helpful dovetail of topics and issues for our judiciary interim work has to do with some of the consolidation of judicial efficiencies and judicial resources, and potentially a conversation concerning judicial districts. This is highly relevant, I think, to the counties as it relates to this conversation associated with salaries, which of course we understand counties, like all government agencies, are struggling with a lack of resources and revenue, particularly our rural counties that don't have revenue sources to begin with. And so I would ask that the county commissioners have a strong conversation about the need to possibly consolidate some of those districts to allow for a greater pool of candidates to run for office or be hired by these county attorneys' offices to increase that competitive edge, and qualified applicants who are interested in running for these offices in our rural communities. So I think that the conversation of salaries and judicial district potentially consolidation or other judicial efficiencies that we can find within the state, this is the right time for that. And so it's going to be very important that the county commissioners and the counties really step up to the plate here and provide some solid direction as to what it is your communities need.
Gentlemen.
Thanks, Mr. Chairman, Co-Chairman Nethercott. We will certainly take that discussion back to the board and see what we can bring back to you.
Senator Cost.
I'm a little slow today, I guess. Thank you, Mr. Co-Chairman. To go along with what Co-Chairman Nethercott had said, that was going to be my question is, can we have a serious look at some consolidation of some of these areas so that maybe there's a fair load in one county and not quite the same load in another county so the two can share that and maybe offset those costs? As all of you know, we're in a time where finances are going to be extremely challenging. And to be perfectly honest myself, I have a very difficult time saying that we need to seriously look at bumping a salary cap up and putting counties themselves in a real financial hardship because of it. So something that can work to the benefit of everybody maybe would be a good consideration by the commissioners. Maybe there's certain jobs that doesn't work for, but I really think we need to seriously take a look at it. Thank you.
Committee, any further questions for the witnesses? Yes, Representative Stith.
Thank you, Mr. Chairman. For Mr. Riemann, you'd mentioned, I think, that there was one county where the county attorney did not reside in the county. It's my understanding that of the 23 counties, there are 6 counties that are currently paying the maximum. So is this county that has an out-of-county attorney, is that one of the counties paying the maximum? And if not, then is that situation relevant to a discussion of the maximum?
Mr. Riemann.
Mr. Chairman, Representative Stith, off the top of my head, I don't know if that's one of those counties at that top end, but I believe that the attorneys that will follow us do have that information.
Senator Anselmi Dalton.
Thank you, Mr. Chairman. Mr. Ribbon, I'm curious, it's my understanding that the average attorney in Wyoming makes $77,000. And I guess if they're solo practitioners, they have to pay their own health insurance and such. I'm just concerned about this whole message of saying, hey, let's go out and really raise it when people have gone to law school too are not making as much in Wyoming across our state. Can you address that concern of mine? Can you also let me know how much the benefits cost on average that you're paying? Are you paying pensions? Are you paying healthcare? You know, what are all those total costs? What are they? Because, you know, the times are tough and I'm just kind of feeling conservative today. Thanks.
Mr. Riemann.
Mr. Chairman, Senator Anselmi Dalton, I think the questions that you're bringing up are part of the discussion that I've had with commissioners that are trying to evaluate those very same things at the local level in terms of other attorneys that are in their community. And that varies across the state. There are certainly competitive markets when it comes to attorneys and perhaps less competitive markets. But I think the underlying thing that commissioners are really interested in is pursuing the need for competent, educated, and being able to retain those attorneys over time. And off the top of my head, I couldn't give you what the average of those benefits look like. I do think we have that data readily available, or at least we could look into that to answer that question more fully as part of this conversation. And I think that's, you know, all of what you're suggesting is exactly why we're entertaining the conversation. We're interested in the conversation because we do have a number of counties that have bumped up against that cap, yours being one of those, and where there are deputies that do make more than the elected county attorney. And with that, I see that Commissioner Fulkerson also has some input, and that's more relevant than mine.
Commissioner.
Mr. Chairman, Madam Co-Chair and Senator, I appreciate the dialogue, but that again, the commissioners aren't looking at an across the board raise for all these positions. We're just looking for flexibility. That doesn't mean we're going to run out and give our county attorney a $10,000 raise next year. That's certainly not the situation. We would just like flexibility as we run up against the cap to consider it if the situation arose. So again, I appreciate the comments. Park County, it's really thin this year and next year. So I would definitely not see any raises in the next 3 years. Again, for us, we're just looking. We would appreciate your committee to consider this just for the flexibility. I hope that helps.
Very good. Committee, we have 4 more witnesses to hear from, so perhaps we might move on to Ms. Wiseman. And gentlemen, if you just want to stop your cameras, but stay with us in case we have more questions for you later. We appreciate your input. Ms. Wiseman, would you introduce yourself and tell us what we need to know from your perspective?
Thank you, Mr. Co-Chairman, Senator Kirkbride and Co-Chairman Nethercott and members of the Joint Judiciary Committee. My name is Erin Wiseman and I am the newly, as of 2019, elected Teton County and prosecuting attorney. It's my pleasure to provide testimony to you today, and I hope to answer some of your questions. I'm joined today also by Dan Aramosby, who is the Sweetwater County and prosecuting attorney, as well as Peggy Trent, who is the Albany County and prosecuting attorney. I'd like to first address a few of the questions that were raised as I was taking notes. The first came from Representative Gray regarding where the 50% came from, which the state is contributing to those counties. And my understanding is that in the early 80s, both Natrona and Laramie County were not able to pay for their county and prosecuting attorneys. And therefore the state agreed to take over that payment. And it seemed inequitable for the state to be paying the full cost of those district attorney salaries while not contributing to the counties. So that's when the change occurred in 2007, where the state thereby agreed to pay 50% of the salary of the elected county and prosecuting attorneys. In addition, it is my understanding that the county does pay half of those salary benefits, which also goes to answer another question that was raised. I believe Ms. Representative Pelkey also raised a question about, I'm looking at my notes here. I'm sorry, Mr. Chairman, I'm not finding the note which Mr. Pelkey had raised. So I'll proceed to the presentation. You received our written materials, and I did not number those, and my apologies to the committee for not numbering those. The first 2 pages, however, provides just a brief summary of the background of the county and prosecuting attorney salaries, the legislation, and then our recommendation. The 3rd page you'll find contains the 3 statutes which are at play: 18.3.107 regarding the county and prosecuting attorneys, and the link to the district attorney's salary, which is 9.1.802. And then I also included Wyoming Statute 5.1.110, which is the statute pertaining to the district court judge's salary that is now at $160,000 as of July 1st, 2019. But to begin with, our PowerPoint presentation, and I won't belabor it because I do take Mr. Chairman's thoughts to heart, which is to be brief and succinct to allow that discussion to occur. The 1st and 2nd page of our PowerPoint presentation just essentially highlighted that history. And as the committee is aware, the minimum salary is $35,000 and no more than the district attorney salary set at $100,000. Certainly the Board of County Commissioners in each county has the local control to set the appropriate salary for its own county. And that's really what we're seeking with this amendment as proposed, which would be to enable and encourage counties such as Teton County, which is quite disparate and unique compared to other counties. And I hate to call Teton County special because we kind of get a bad rap for that. But my county is quite unique in that I have 2 deputy county attorneys who are at $144,000 for their annual salaries. Another deputy is at $130,000. I have 3 new deputies, which I just hired since I came into office, and they are all bumping up at the $100,000 cap, which I am at as well. As was pointed out earlier, there are 6 counties that are already paying the maximum of $100,000. 8 counties are very close to that maximum. And at least in Teton County, we anticipate next fiscal year, there will not be raises or increases along those county salary matrices. However, I think this sets us up nicely in the future. 2023 would be the effective date if any new legislation were to occur. And if not 2023, then we're looking at 2027. So I think it's really about the legislature being thoughtful and looking into the future about how we can best set up these positions, whether it's myself that's in this position or another attorney. I would hope that the state of Wyoming, as well as our local commissioners, could support that movement. And I think it's necessary. It's also interesting that when the legislature took this up last in 2009, the state of Wyoming in our country was coming out and in a recession at that point as well. And we're feeling those fiscally tight strings right now as well. But I don't think that is a reason to prevent this legislation moving through. And I'm so grateful for the committee for taking time to look at this issue and study it. You have a lot of information before you. My county has also done quite a bit of research in terms of comparing salaries in other states, Utah, Idaho, Montana, and I would be happy to provide that data to you at our next meetings. At this point, I would like to turn over the presentation to Mr. Aramowski, and he can take you to the PowerPoint slide, which he'll get into further. I would certainly stand for any questions, however, Mr. Chairman and Co-Chairman Nethercott, if you have any for me at this point. If not, I would say it's time to hear from Mr. Aramowski.
Any questions from Ms. Wiseman? Yes, Representative Jennings.
Thank you, Mr. Chairman. Ms. Wiseman, would you agree with the two former testimony givers that flexibility is the most important part of this?
Ms. Wiseman?
Thank you, Mr. Chairman and Representative Jennings. Yes, of course, I think flexibility is really what we're asking for and seeking, recognizing that each county is very different and unique. And again, setting a cap of 160,000 to be equal with the district court judges provides that flexibility into the future so that there's not a hard and fast number. And there are many counties that will probably never reach that amount. And it's not that I am seeking that amount at this point, but when you have counties such as Teton County, Sweetwater, and others that follow a county matrix, it is very difficult, I believe, to recruit the right candidates to seek these positions when those that are in the deputy roles make such a significant salary over and above the elected county and prosecuting attorney. Thank you, Representative Jennings.
If there are no further questions from Ms. Wiseman, Attorney Aramowski, come forward. And if you can turn on your camera, if you can, or you can just testify orally if you want.
Thank you, Chairman Kirkbride. I have to apologize. I initially tried to get on. I was kicked off by the host. It's not the first time I've been kicked out of a party. This one seemed to be important, but I had to get on my phone, and for some reason the video was not working. So if I could testify over the phone, I appreciate it, and I apologize for the inconvenience for the committee, to the committee. I'll give you a little background about myself. I am in my second term as Sweetwater County Attorney. I graduated from the University of Wyoming in 1996, and I came home to Sweetwater County, where I was born and raised, and I immediately began working at the county attorney's office. I did that for 2 years. I grabbed my education and training and experience and went in the private sector for about the next 18. Later on in my career, I wanted to go back to prosecution, and that's what brought me to run for office, and also brings me here today because I think my story does resonate a little bit with what we are approaching the committee with in this request. First off, if we could look into slide 4 of the presentation, the American Bar Association has basically set the standard of what qualification the prosecutor needs to have. And please take this to heart when I am going over what skills and professional skills that are required or desired for this position. In a sense, I want to explain why it's an important position to the people of Wyoming, to the people of our individual counties. But as Ms. Weissman stated, our proposal here today is really about giving local control and flexibility to the individual counties. So to go into what the American Bar Association standards for a prosecutor are, is that they should have strong professional qualifications, and then there should be effective measures used in that jurisdiction to retain excellent prosecutors. I can give you a laundry list of skills that are required and professional skills that are required for this job. But to suffice it to say that we are trial attorneys, we have to be cognizant of constitutional issues at all times. That's first and foremost. And we also have to have a working knowledge of about every form of forensic and investigation, as well as, which goes from DNA to forensic ballistics, handwriting exemplars, drug recognition, toxicology, psychology, forensic accounting, a variety of different topics that we have to be apprised of at all times when we're doing these cases. And that starts from the inception of a case, not just prior to trial. when you become a prosecutor in your first couple of years, and I have a young staff, I have 3 or 4 very, within 3 years of passing the bar in my, has my deputies. And what they do is they're learning these as they go along. They're getting the trial experience, they're getting the education. We send them to training to be able to acquire these skills. And ultimately the goal is that I can groom these deputies into career prosecutors so that they can maintain that knowledge that is provided by the taxpayers, that they can maintain that in public service. That is ultimately the goal I have for my office. And the prosecution office is where you can gain this. Subsection D, compensation should be commensurate with the high responsibilities of the office, sufficient to compete with the private sector. I do not believe that we should be competing with the private sector toe to toe. I believe the market is always the proper place for the cream to rise to the top. However, prosecutors have a different standard and a different set of skills than a private attorney. I know, I was in private practice for many years. And those skills you have to attract the right people, and you have to be able to keep them in that position. So they are used in favor of public works. Private attorneys have a different set of goals, have a different set of standards. I understand that. And so we're not asking that we're stealing from the private attorney pool, but rather that we have at least something there that is an incentive for someone who is minded to go into the prosecution field, that they're not drawn out to the private sector because the lure of the potential of more money. And if anyone has any questions at this, as I move along, Madam Chair, Chairman Kirkbride, I could take them before I move to the next slide.
Mr. Aaron Mosby, I'm having trouble accessing your PowerPoint. I don't know if the rest of the committee is or not. And maybe that's an issue for our own LSO staff. Does anybody have any help for me in that? Representative Washit?
Thank you, Mr. Chairman. I have printouts of that PowerPoint in my notebook, and that's what I've been following along with.
Mr. Chairman.
Yes.
Thank you, Mr. Chairman. If you're looking on the website, it's in item 3-03 and it's at the end. It's in the 15-page handout that the prosecuting attorneys provided.
It doesn't look like a PowerPoint. It's black and white. It is in the form of slides, but it's not an obvious PowerPoint. So it looks like it's just part of like written materials.
Starts on page 4 of item 3-03 on the website.
Thank you.
I get it. Maybe I was the only one having trouble in it. I see the materials. Representative Washit?
Thank you, Mr. Chairman. A quick question. How many counties do we have where the deputies are earning salaries higher than the elected?
Mr. Chair, Madam Co-Chair, we, I believe Campbell, Teton, Sheridan counties have deputies that are currently being paid more than the elected. In Sweetwater County, the chief deputy, I believe by the end of this summer, due to the matrix, will be being paid more than me. And as a quick aside, earlier this year, I was applied for the district court judge position for Sweetwater County for the 3rd Judicial District. I made the 3 cut, and the governor, in sound discretion, in my opinion, did not choose me. So, but during that process, I was working with my chief deputy as to whether or not she was going to put in for the position, because typically when there's a vacancy, 3 candidates from that political party of the elected would be presented to the commissioners. She would have been taking a pay cut by the end of the year if she was going to be putting in her name for that position if I were to have got the judgeship. Honestly, I couldn't figure that there would have been 2 other candidates within Sweetwater County that would have even submitted their name in competition to her. But you know, that's the problem that we were facing in this aspect. And I think it's probably even more so a problem in Teton when you're having them make the 2 deputies make $44,000 more a year than Ms. Weissman.
Any other questions, committee? Mr. Aramosby, anything else you wish to say?
Yes, Mr. Chair, we have several other things I'd like to go through, and if, per each slide, and I'm sorry I'm calling them slides, but that's how they're presented to me on my computer. But the next thing I'd like to speak about is the National District Attorneys Association prosecution standards. It would be the 5th page or the 5th slide on the PowerPoint presentation that we provided. Basically, what that does, what the National District Attorneys Association has set as a standard is that the salary of a full-time chief prosecutor should be at least the salary of the chief judge of general trial jurisdiction. In Wyoming, general trial jurisdiction is the district court judge. The factors that they determine are the benefits of the jurisdiction to encourage highly competent people to seek the position. And I think that's really the crux of this, is that we are asking for the flexibility for the county commissioners of our respective counties to determine what the benefit is. What's it going to take to entice people to run for this position, to take on a deputy role and retain that deputy role throughout. And I think that is unique to each county. And I believe by raising this standard, or the cap, to the standard recommended by the National District Attorneys Association, then that gives them that flexibility. The level of compensation should be able to retain and retain those deputies. For instance, I had a deputy working for me. We sent him off to a homicide training in Arizona. He used it as basically a job fair. And next thing I know, he comes back, gives me his 2 weeks resignation, and went to greener pastures with the education and training provided by the taxpayers. And so that is the issue that I think we're having. And I think it's throughout the state. It's difficult to hire as well as retain. I had a position open up for 6 months. We put it out at the end of the school year, hoping that Wyoming graduates would be enticed to apply. We kept it open throughout the entire summer to when the bar results came out, and we only had 3 applicants the entire time. And they were from out of state, and they were, in my opinion, subpar for the position we were looking for. So difficulty in hiring and getting applicants is one thing, and retention is also a problem with some of these counties throughout the state. If you can join me in the next slide, the National Advisory Commission on Criminal Justice Standards. For the purpose of salary, the prosecutor should be considered to be on the same level as the chief judge. Both positions require and exercise a broad professional discretion in the discharge of their duties of their office. This is important in many ways, because this ties us into the district court judge. Why do we have the standard that it has to be a district court judge? And why not a circuit court judge? Why not a municipal judge? The importance of this is to note that the prosecutor is the chief executive officer of the county, the chief law enforcement officer of the county. And we have to exercise broad discretion in many ways. And we have a tremendous responsibility. And along with that, as this committee is well aware, we have tremendous power in doing so. We have the ability to arrest. We have the ability to take protective custody of children. We have the ability to submit search warrants. We have the ability to prosecute juvenile matters, neglect matters, terminate parental rights, very important responsibilities, and the power that goes along to enact that is very high. And so we have to exercise proper discretion. We have seen cases where that has been abused. We have seen where that discretion has been poorly operated. And the answer to that in fixing that problem where that occurs is through the election process. Now, if we have a poor prosecutor, do we have the ability to entice somebody to come in and run against them? Somebody qualified. If we don't have that, then that person remains in office. So we have to answer to the electorate every 4 years, which is a little bit different than judges. As we all know, judges are retained, and that retention standard is a little bit easier to go by than running for office every election, as I'm sure this committee is aware. So the power of the prosecutor and the responsibilities of the prosecutor go well beyond those of the circuit court judge. They do match up with the abilities of the district court judge, even though they're in two separate two different branches of the government. And I would note that everything that the judges see, the district court judges see in front of them, are initiated by the prosecutors. When we decide to make a charge, or we decide not to make a charge, or when we dismiss those charges, we also have to do these in terms of a code of ethics that are unique to prosecutors due to the tremendous power and responsibilities that we hold, that we have to abide by, and much to the chagrin of the public. Sometimes we make calls that we have to do so ethically because we're ethically bound that the evidence isn't there, that a constitutional right was being abused or violated on behalf of the defendant. And that comes back, through the media and the social media online of great displeasure of the public to our actions, but we are bound ethically to do so. And so I believe that's where the National Advisory Commission on Criminal Justice Standards pulls us into the district court judge category. And finally, I would just address the reasoning behind that, and that would be the next page, 7. It really boils down to giving the flexibility to the individual counties to allow them to have a unique perspective on what their county needs, what it's going to take to retain within their county. We're not asking an across the board 160 for everybody. But in essence, when we leave the cap at 100,000, we are in certain counties have set that salary. The state has set that salary by not allowing that flexibility. By expanding that, then it allows the counties to provide their own, what they feel they need for that, for the salary. I would point out that Montana allows the counties to do it. Utah, Colorado. There are some limitations. Montana uses the district court model that we're presenting, has there, saying that the county attorney cannot make more than that. But they leave it up to those individual counties to make that call. And eventually, it better serves the respective counties. There's nothing more important to me than decisions being made about an individual are better decisions when they come closer to home. So local control better serves the people of that county as opposed to something farther removed, such as the state. At this point, I would ask for if there's any questions. Madam Chair, Chairman Kirkbride, I would be happy to answer, and then Ms. Wiseman would go back to her and she would finish off the presentation.
Okay. Any questions for the gentleman from Sweetwater County? Any questions?
Mr. Chairman, thank you very
much. Representative Stith.
Mr. Chairman, thank you very much. And Mr. Aramosby, thank you for your presentation. And I appreciate the work that you do for the residents here in Sweetwater County. I think you've, one thing I appreciate about you, Mr. Aramosby, is that you are a working county attorney. You actually go in and you do cases and you go to court, you do trials, you roll up your sleeves and you do the work. So I just want to give you a shout out for that. With respect to 2 questions. First is, given that our unemployment rate's going to reach 15% and maybe go higher, do you expect to have recruiting difficulties this year? And the second question is a bigger question with respect to local control. As you know, the Wyoming Constitution, Article 14, Section 1, requires the legislature to set the salaries of county elected officials, the county attorney, the county clerk, the county sheriff, and, by the way, school officers. Are you advocating for an amendment to the Constitution?
Mr. Aaron Mosby.
Thank you, Chairman Kirkbride. Representative Stith, first off, regarding the unemployment rate and problems with recruiting, I honestly couldn't tell you where we are in that regard. I think in Sweetwater County, we are unique, having practiced there and growing up there, that even though some places bust, we never truly do bust. The problem is the recruiting problem, I don't believe, is indicative of the unemployment rate. And it's possible that we may have more interest throughout the state if we did have an opening. We are now fully staffed. It took us 2 years to fill that last position. So I don't necessarily know whether or not that would be an issue or not. I would think that this is a good place to work. However, it may not be. Coming out of law school, I think would be an ideal place to work, but the retention is probably a bigger issue in the long run. And Sweetwater County's in the private sector, in speaking with my friends that are attorneys as well, that they're not at want for clients. So there's that aspect. And specifically to your second question, we're not asking that anything. I don't believe that the Constitution needs to be amended to allow for this, because they allowed to set, but the statutory provisions have always provided a cap. And 183107 is the initial one that provided the cap for the county attorney salaries, which set that at the same level as district attorneys. Now, I've spent a lot of time talking about the district attorneys, or basically the prosecutors. District attorneys are strictly prosecutors, but county attorneys have the additional duties of civil representation for the counties. And that's extremely broad in what we do. We represent every aspect of the county, including the sheriff, who will be speaking here momentarily, and we handled his liability issues with the detention center. Teton County has different civil problems than Sweetwater County does, and so we do all of those things, and I think that's where the statute comes in. But to allow the counties to cap initially at 100,000, which was discretionary, and that was tied us into the district attorneys. What we are asking is that the district attorneys be tied in to the district court judges, which I believe is allowed by the Constitution and allows the county to ultimately set the final. The state has done it in a cap. And so I don't think we need to address anything regarding an amendment.
Any other questions before we go back to Ms. Wiseman?
Mr. Chairman.
Oh, yes, Brian.
Mr. Chairman, Representative Stith, I just wanted to respond to your question about the Article 14, Section 1. I believe it was in the 1940s, the Supreme Court held in a case that it was acceptable in statute to set a minimum and maximum salary for those stated positions in that constitutional provision.
All right, thank you. Ms. Wiseman.
Thank you, Mr. Chairman Kirkbride and Co-Chairman Nethercott. The next few materials, I'll be brief and judicious with your time. The next slide that I will speak to is Wyoming Statute 183107. And we simply just included this so you could see the full statute, and you'll note subsection C, it is highlighted. That is the statute that's applicable, which Mr. Armosby was just speaking to, which again sets that minimum and maximum to be related to that authorized for the district attorney under 91802. The next page of the materials provides the statutory language currently in 91802, which went into effect again January of 2011, that each district attorney would receive the annual salary of $100,000. And then our next slide, which is slide 10, Wyoming Statute 91802 proposed. And this is the language that we are proposing in red. You'll see it would be an amendment to subsection D, and it would strike the provision at the end of that sentence and replace it simply with January 3rd, 2023, each district attorney shall receive the annual salary authorized for a district court judge under Wyoming Statute 51110A2. And I think what's important, I feel as though I'm harping on this, but it really is key, is that what we're asking for really honors the local control that Wyoming finds so important, and each county finds so important. It would allow counties such as Teton County and Sweetwater and Sheridan to, again, correct any deficiencies which exist now and align the salary of the elected to that of its deputies and the matrices. And again, the matrices which some of the counties have in place, that's not something that I control. That's vetted and researched and arrived at with good data. And so what my deputies are receiving, I believe, is the right and correct salary, even though they may not see increases for the next few years based upon our fiscal dilemma that we may find ourselves in as we move through these next few years. However, the national standards really support the legislative change which we're seeking, which is to align our salaries with that of the district court judge. There are other options, and I certainly recognize that, whether it's circuit court judges, district court judges, or another model, but this is the one that we've proposed, and we look forward to working with the committee as you gather more information and data. I think the last page of our materials is really important, and it's simple to get to. It's a color-coded Excel spreadsheet, the very last page. And this shows the elected officials' salaries from January 2019 through December 2022. And it's each county, and it's organized by those elected officers: clerk, sheriff, attorney, coroner, commissioners. And you'll note that we have highlighted in yellow the attorney's salaries. You'll see in 2021, that column, there are green cells, 6 of those green cells, and those represent the counties which are at the 100,000 cap. And if you move to 2022, what is anticipated, which may not be the case based upon where we're at, are those salaries which are coming very, very close to that $100,000 cap. It's notable that we had 11 newly elected county and prosecuting attorneys or prosecutors, one being a DA, that took office and began our terms in 2019. And it really goes to what we're seeking, which is to ensure that the goals of Wyoming and each county are met with the right candidates, the right folks and attorneys who are seeking these positions. As Mr. Aaron Mosby stated, it is an intense job. The duties and demands required of the job, I think, also demand that the pay should be equitable. We are the highest law enforcement officers of our counties. It's an amendment that would simply allow this new salary cap to be at a level which again gives local control and also allows for that alignment with county matrices. I will stand for any further questions, but I am sincerely grateful to the committee for your time and your efforts on this topic. Thank you, Mr. Chairman and Co-Chairman Nethercott.
Thank you, Ms. Wiseman. Representative Pennell has a question.
Thank you, Mr. Chairman. Yes, Ms. Wiseman, my question on the district attorney, that fee is paid, if I'm pretty sure, by the state, correct? And does the but the commissioners don't set that individual salary, if I'm correct. Is that also true?
Ms. Wiseman?
Thank you, Mr. Chairman and Representative Pannell. That is correct. The two district attorneys that we have in Natrona and Laramie County are at $100,000, and that is not set by those local county commissioners. So it's just the remaining counties that have county and prosecuting attorneys, or in the instance of simply just a county attorney for those counties that are set by the commissioners.
Any further questions? Right, should we move? Oh, Representative Pannell.
Thank you, Mr. Chairman. Well, just to follow up, and so then if we were to pass this amendment onto or what you're requesting, automatically the district attorneys would make that $160,000 a year in the next election. So I mean, there wouldn't. So the state would be automatically giving that raise immediately, if I understand the way it's worded in this information that was sent out. Am I correct in that?
Ms. Wiseman?
Thank you, Mr. Chairman and Representative Pannell. You are correct. That's how it's drafted. The language could certainly be tweaked or modified to allow for a range there as well, but that's how I have proposed it at this point. And I think it's probably wise for the next time we come back to look at perhaps numbers, data, other information that may help you in understanding, the uniqueness of our counties. I do have one more thing, Mr. Chairman, if I may. I believe the question that I was trying to answer when I first began was related to the county and prosecuting attorney that lives outside of that county. And I believe it's Weston County, and it's that county attorney who is in another jurisdiction who serves as the part-time county and prosecuting attorney. And that salary is at $60,000, if that helps the committee.
Okay. Ms. Wiseman, thank you for an excellent presentation. I think we'll move on to Laramie. I see Ms. Trent next in line. So Ms. Trent, welcome.
Thank you, Mr. Chairman and Co-Chairman Nethercock. I just would like to add a few items to this discussion, just to kind of give you an update about the association and how their position about the salary increase. After, I think about a year ago, Joe Barron from Crook County and myself approached UW Law School in order to assist us in attempting to get an idea of the number of cases and the diversity in each of our systems throughout the 23 counties. There's always been studies as it relates to defense attorneys, such as you've had with the public defender's office, but not related to what is an adequate or too much of a caseload for prosecutors. So we wanted to do a comparison ethically to see how much is too much and what we are handling as elected officials. And I think as a county and prosecuting attorney personally, there's a lot of demands on our time in that dual role. And specifically with COVID-19 right now, we've been representing the county health officers and all of that has been involved that we can never plan for. Just when I think, hey, things are calming down in my office, another item will hit and we're pulled in those directions, whether it be as a county attorney in our civil representation or as a DA in our position as to those items. So right now, the law school is conducting that study. We hope to have that information available to you shortly. And I think, as Diana Lozano has indicated in previous testimony for public defenders and the issues that she has had in hiring attorneys, as prosecutors, we are having the same issues as we move forward and recruiting prosecutors to work for these high stress, but yet rewarding at times jobs. And so you'll find that we hope to provide you that information in the upcoming months from the law school. But at this point, just wanted to let you know that we're trying to get unity also in how we're prosecuting throughout the state. I think we've discussed in past about a coordinator position, if you recall, or some type of position to bring the level of what we're doing together in all of our communities. So I appreciate that you've taken the time. I recognize that asking for pay increase for attorneys at this period of time and difficult of our community and our state is really hard for everybody to talk. But I have confidence that this state of Wyoming, we will pull through all of this, and then we will come to better times. But we still have the demands as prosecutors and as county attorneys. Thank you very much.
Representative Washington. Representative Washington.
Thank you, Mr. Chairman. Space bar wasn't working there.
Me
Question
too.
for Ms. Trent. I think this is somewhat related. It's a little off, but as I understand it, new deputy district attorneys are paid substantially less than new public defenders. And I was wondering if she could comment on why that is, and does that have any bearing on the ultimate salary that we pay the elected district attorney?
Ms. Trent.
Mr. Chairman, Co-Chairman, Representative Washut, yes, we are paid our starting prosecutors. As a matter of fact, one of my prosecutors who was seasoned just left to go to the public defender's office after the pay raises that were given this past year in that office. So we are seeing definitely issues in the pay and what we're receiving. My starting, just to give you an idea, and you have to remember, I'm old. I started as a prosecutor in Columbus, Ohio, making $14,000 a year. So to me, to start here in Albany County, it starts at $58,000 to start. And then my chief deputy, just recently, I was able to give her a raise through, because we had the other deputy leave, so we scraped the money to the other. My chief deputy was making $72,000. She is now up to $85,000, and then I'm paid $95,000. We are in a situation where, I have a high turnover, and I am probably in the best position, if you will, in recruiting in the state of Wyoming because of my relationship with the College of Law. I have numerous interns, so we take advantage of that program, intern, extern, but we are not making nearly, what we see our public defenders. And I believe when we presented our budget for the 160 funds to the governor recently, Joe Barron and myself, I made sure I told and was talking with the governor that we have to stay even with the public defenders because we are a system of the criminal justice and we have to move up at the same levels. Thank you.
I see Representative Washington for a follow-up and then Representative Pennell.
Thank you, Mr. Chairman. So what I'm trying to get at here is this an ANI pay scale determination, or is there statutory reasons why public defenders are paid higher than deputy DAs?
Ms. Trent.
Chairman Kirkbride, Representative Washa, that is correct. ANI does, for the state of Wyoming, sets those salaries as well as attorney generals. Ours is set individually by each county. And although we do salary comparisons to attempt to be comparable with prosecutors and public defenders, ours is more looking at AGs, which we're not even on the same level playing field as the AGs even.
Representative Pennell.
Thank you, Mr. Chairman. My question, Ms. Trent, would be, can't your commissioners give a raise, to your deputies? There's no cap on their salary, if I'm correct. So isn't that a county issue as far as making, paying more to the deputies?
Ms. Trent?
Mr. Chairman and Representative Panau, yes, that is a local issue that I am very aware of. But as you can imagine, in Albany County, we do not have the funding and resources in our budget to continuously add to that amount of money. I attempt to always make sure that my deputies are getting pay increases. I've also tried to get creative, Representative Panau. I've even tried to think of ways to give mental health days, to give more time off and rewards after a jury trial, after the number of jury trials. And with COVID right now, our jury trials are getting pushed out to August, which we will have every 2 weeks. There's no recovery time. We try to give mental health days. I try to do more flex time. I do as much as I can when I don't have the monies in order to pay them. But with the salary cap for the prosecuting attorney, you're trying to move these up. At one point, just so you know, my chief deputy was making more than what I was paid in my first term. But yes, the commissioners do have that ability, but it's limited in what we can do for the elected officials.
Madam Co-Chairman.
Thank you, Mr. Co-Chair. Just kind of in response to the issue regarding commensurate salaries with public defenders and county prosecutors, the disparity there is not as a result of A&I. I don't think that's accurate. If you recall the testimony from the last interim from the public defender's office, from what I will refer to as the Campbell County debacle, the challenges associated with the public defender's office, you heard testimony that they lost at least 5 public defenders from that office in Gillette to the county attorney's office up there, because the county attorney in Campbell County, which is a unique county in and of itself for its revenue generation, was able to pay its prosecutors significantly more than the state can. And so the differences in the sources of salary for county attorneys and public defenders is significantly different, including the benefit structure. So I think we need to be very cautious about that comparison, recognizing that certainly in Albany County, maybe that analysis looks very different because Albany County doesn't have coal mines like Campbell County does, but in Campbell County, certainly the situation is far more disparate. So we just need to acknowledge those differences. Do I think that there should be some type of similar understanding between entry-level salaries for attorneys and public service within our state? Certainly, but I do think that the effort and intent to try to make those similar probably isn't going to be achievable in light of the county commitment and the differences between our counties and the state.
I saw Representative Jennings and Representative Pelkey. Representative Jennings.
Thank you, Mr. Chairman. I have 2 questions for Ms. Trent. Ms. Trent, appreciate you giving us testimony. Always appreciated your testimony and the way you presented it. So I have 2 questions that I'd like you to tell us how we should go back to answer. How do we answer the public when the public is, their average income has gone down by about 10,000 or more per year, and the state's lost revenue maybe, 30, 40%, which I understand we're only paying half of these attorney fees or these deals. And then number 2, so first of all, how do we answer that back to our constituents? And secondly, this feels like, and you could address it a little bit, but back to our constituents, this is one government attempting to outbid another government with the public funds. So if you could address those 2, thank you.
Ms. Trent.
Mr. Chairman and Representative Jennings. Outstanding question. How do you justify it to the constituents? And that is a question, and I think also to add upon what Co-Chairman Nethercott said, is right now, more than anything, right now, and we need leadership as we move forward in these economic times that are moving forward. And what Co-Chairman Nethercott reminded me, and I appreciate that, is we were also looking at, similar to what public defenders, is the caseload. And we, unfortunately, in these times, we were prosecuting through when everyone was shut down, not shut down, but restrictions were in place. You will see, we are starting to see an increase in caseloads. Our caseloads are increasing as we speak. And I hate to say this, I'm seeing more violence that is coming about as a result, maybe of the restrictions of domestic violence and other crimes that are occurring lately. As we move forward in these uncertain times, it takes people with experience not only representing the county commissioners and the county elected officials and our county health officers, but also in the courtroom and as a district attorney to understand and prioritize our caseloads. As you saw the drugs that were coming through, and you've had discussions as a joint judiciary through revisions of our programming pieces for incarceration. We've revised our criminal justice system. We still are moving through that. And you have to continue to retain that talent and leadership to get us through these economic times. So although you're right, we are facing uncertain times, at the same time, you want to recruit the best you can in these attorney positions. And I would submit to you that we are relied upon quite a bit as we move through these uncertain times through the county attorney position and the DA. The caseload didn't change because of COVID or the pandemic, or it did not change because of what we have in our economic times. These are the times when we have to pull together and have good leadership to move through it. So my position would be that's how you justify it. That doesn't go away due to economic times. And just so you're aware, during these times when people were asking for variances, the county attorney was the one who is tasked with the enforcement of those variances. We're the ones who have to do the most unfavorable. We're the ones that get tagged frequently with what's going on in our community, whether it's popular or not. So I feel, you know, although these are difficult times to ask, I'm not saying that I'm going to benefit from the pay raise. It will come from the next down the line if the county commissioners so desire it. And it would not occur to these current elected officials, but to those running in the next election. Thank you.
Okay, for the sake of making progress through the morning, let's have one more question from Representative Pelkey, and then we'll move to the sheriff. Representative Pelkey.
Thank you, Mr. Chairman. I have a quick question for Attorney Trent. As I recall, there was in statute a minimum number of days that the county attorney actually had to be at the office. And I don't recall where that is, whether it's in the county commission or the county statutes, or if there's a state statute. And I know that's not an issue with you because I email with you sometimes at 6 in the morning and you're usually always there. But I'm curious if that does exist. And I recall a reference being made to that regarding your predecessor. If the Prosecuting Attorneys Association would be amenable to having that restriction altered.
Chairman Kirkbride, Co-Chairman Nethercott, and Representative Pelkey. I have not run that by our association, but I can speak as the Albany County Attorney. It absolutely needs to apply to not only the county attorneys, but every elected official should have a set amount of times. And there is a state statute. I think the last time I checked, Not that I'm the keeper of watching my elected officials in the building, but I do get asked that question rather frequently. It is something like a certain amount of hours per month, which is not appropriate, and it should be that they're working full time. And I guess that becomes an issue for the electors when they do re-election. But I can follow up with my association. I don't believe that that will be a problem.
Thank you as always, Ms. Trent. For another piece of the puzzle this morning, let's go to Green River to hear from Sheriff Grossnickel.
Good morning, Mr. Chairman, Madam Chair, fellow committee members. First of all, on behalf of the sheriffs, we want to thank you for addressing this issue and allowing us to provide some input to it. Briefly, I want to introduce myself. My name is John Grossnickel. I'm the elected sheriff here in Sweetwater County. This is my first term. A little bit of my background. I have a Bachelor of Arts degree from Chadron State College in criminal justice, along with a Master's of Science degree in criminal justice, law enforcement administration from Columbia College. I have 24 years of law enforcement experience here in Sweetwater County, 23 of that being with the sheriff's office. So I have a good history of the sheriff's office in general. Without beating a dead horse, we've talked about the statute that sets a salary for the sheriff of not less than 10,000 or more than 100,000 a year. The Board of County Commissioners, also in that statute, is allowed to set the annual salary. Section small b states that the county officer shall be compensated for all duties prescribed by law to be performed by them. Section little f, and it's been talked about quite a bit before, provides the compensation by the state of Wyoming to subsidize the cost of wages for the county attorney salaries, along with the deputy county attorneys. As the commissioner stated, that this is not the case for the sheriff and the deputies within the sheriff's office. That is solely on each county entity. Some of the duties of the sheriff that's set by statute, 18.3.602 allows the sheriff to retain deputy sheriffs in order to properly facilitate the everyday duties prescribed by law. 18.3.603 establishes the sheriff as the custodian of the jail and prisoners, along with boarding those prisoners. 18.3.604 mandates that the sheriff serve and execute all processes, writs, and orders issued by the court in all criminal civil cases, along with attending all courts of record within the respective county. 18.3.606 requires the sheriff to provide law and order within their respective county. Going on further, the state of Wyoming and a lot of the major municipalities have seen the benefits of having administrators compensated properly. According to the state of Wyoming, the colonel of the highway patrol had an annual salary of $125,149 in 2019. Additionally, the state of Wyoming indicated the director of the Division of Criminal Investigation had an annual salary of $120,029 in 2019. And finally, the director of the Department of Corrections, as indicated by the state of Wyoming, had an annual salary of $149,624 in 2019. Moving forward, agency administrators in major municipalities within Wyoming. According to the city of Gillette, the Gillette police chief has a salary of $132,119 with a maximum of $152,382 as outlined in their 2020 budget. The city of Casper indicates that the chief of police has a salary of $121,890. The city of Cheyenne police chief has an annual salary of $120,000. City of Rock Springs police chief, his annual salary is $111,660. And the city of Green River, their police chief has an annual salary of $107,000 currently, but has a maximum of $125,091. The difference is the state and local administrators are tasked with either the law enforcement aspect of the law or the correctional aspect of the law. The sheriff is unique and has the responsibility of the enforcement of law as the custodian of the jail and prisoners and the execution of civil process. The reason we believe that a salary increase should be looked at, brings the sheriff's salary comparable to a level of that of other state and local administrators. Also allows the decision and control to go to the Board of County Commissioners with respect to their own communities. And finally, this will attract and retain qualified and experienced individuals as sheriff, as deemed by the public. Again, just recapping, the current salary set forth January 3rd, 2011 is not less than $10,000 nor more than $100,000. As sheriffs, we propose that the salary change starting January 3rd, 2023 be not less than $40,000, which is what our lowest paid sheriff is in the state, and no more than $140,000.
Thank you, Sheriff. Any questions for Sheriff Grossnickel? Representative Pennell?
Thank you, Mr. Chairman. Just a quick question to remind me, or as a reminder, I was going to ask the sheriff what, I can't remember, but is there a limit on housing that the sheriff is still allowed? Is that still in place? And if so, what is the dollar amount on that? And yeah, because I can't remember. Thank you.
Sheriff?
Mr. Chairman, Madam Co-Chair, and Representative Pennell, it is in statute, and I read this a couple of days ago. I can't remember what the limit is, but it still indicates that there's a stipend for housing for the sheriff.
Representative Jennings?
Thank you, Mr. Chairman. Sheriff, I appreciate your testimony and being here this morning. I'm going to ask basically the same question I asked prior. So at a time when the average wage across Wyoming is dropped over the last, I don't know, 10 years or so by $10,000, and the income into the state is in grave jeopardy, how would you propose that we answer that question back to John Q. Public as to why we would see the need to raise your wages when the people that you serve, their wages on average are going down? Thank you, Mr. Chairman.
Sheriff Grossnickel.
Mr. Chairman, Madam Co-Chair, and Representative Jennings, I believe the message should be that this is a tool that should be given to the county commissioners, in particular with the sheriff's salary, as the counties are the ones that pay that bill, to produce higher quality law enforcement, which the public has been demanding for decades now. And again, it's a tool. It doesn't necessarily mean that those wages are going to go up, but it gives them the flexibility to compensate those elected officials that have education and experience, so they don't move on.
Representative Jennings.
Thank you, Mr. Chairman. So, Sheriff, let me pose this question to you, because it seems like a common thread through all the testimony this morning that flexibility is the real goal here. And we've all acknowledged that the state's revenue is in jeopardy, and certainly missing from what it would have been even 6 months ago. So if you want this flexibility, how about more flexibility for the commissioners and less skin in the game from the state? Say we were to move that, would you feel like that was a fair enough trade-off for that flexibility? Thank you, Mr. Chairman.
Sheriff Grossnickel.
Mr. Chairman, Madam Co-Chair, Representative Jennings, I believe, speaking with my local commissioners, that absolutely, when it comes to, in particular, the sheriff's position, they would like that local control and flexibility to be able to compensate the sheriff's wages as they deem appropriate.
Okay, committee, anything else? Representative Washit?
Thank you, Mr. Chairman. Sheriff, just to be clear, the state doesn't subsidize sheriff's wages at all in any way, correct?
Sheriff?
Mr. Chair, Madam Co-Chair, Representative Washit, that is correct. The state does not compensate the wages for the sheriff. And also, while you're here, Representative Washit, go Eagles.
Any other questions for Sheriff Grossnickel? We have two more witnesses who were not listed on the agenda, but they've applied to present testimony. So Mr. Odakov and Ms. Muir. So should we admit them now, Mary Beth?
I will do right now.
Representative Gray.
Thank you, Mr. Chairman. I've got a question for Mr. Ryman. Are we going to get a chance to go back one more pass after everyone's done? Or is he going to leave?
I think he's still here, so we'll hear from these other
okay. Thank you.
Other witnesses and then go back if there's any follow-ups like you're talking about.
Mr. Chairman, did this freeze up on us?
Senator Von Flater?
Yeah, I wondered if it froze up on us because nobody was speaking.
No, we were waiting for two additional witnesses to be admitted to the meeting. So maybe Representative Gray, since Mr. Riemann is there, why don't you ask your question of him now while the other folks enter the room?
Mr. Co-Chairman, I do believe that they are present, Mr. Odakoven and Ms. Muir. I can see them on the YouTube feed, so they aren't here with us.
Okay.
If you scroll to the second screen, they are there, and they'll probably pop up on our first screen here shortly as soon as they are given the floor.
All right, now I see them. Okay, well, let's hear from Mr. Odakoven and then Ms. Muir. And I assume they've been listening and following the topic this morning. So welcome, and Mr. Odakoven.
Thank you, Mr. Chairman. Byron Odakoven, the Executive Director for the Wyoming Association of Sheriffs and Chiefs of Police. Thank you for the opportunity to comment via the Zoom meeting. And it's been interesting on watching on the YouTube on one computer and waiting in the waiting room on the other computer for the camera to light up and be on the go. So it is a new experience for sure to do all of this through the electronic format. Let me begin by saying that I appreciate the initial comments and the discussion from the Executive Director Riemann from the County Commissioners, spelling out what I believe succinctly is the issue of the day, and that is to allow the County Commissioners to set the wage for, or the wage scale, or the wage range for the elected officials within their county. Specific to the office of sheriff, there is, and reinforce the point, there is no state money involved in the office of sheriff. It is strictly a county commission function, and it is at the local level that decision is being made. It is not the discussion necessarily that the legislator, when he goes home, would have to say, why did you give the sheriff a raise? It would be the question of, you gave the commissioners the flexibility if they choose to raise or in fact lower the wage for that 4-year period of time. That sword swings both ways. I would note, as Sheriff Grossnickel pointed out, that we have a wide range of salary within the office of sheriff. He pointed out that our lowest paid sheriff is at approximately $40,000 and the highest at $100,000. Much like the county commissioner, or excuse me, county attorneys and district attorneys, we have several of the undersheriffs, captains, et cetera, within the offices who are currently being paid more than the sheriff. In fact, when I was the sheriff in my final year of the term, both of my leading deputies as captains made almost a third more than I did as the sheriff in order to be able to retain those competent individuals in that very skilled position. So I think if we're going to ask for badge number one to be competent, skilled, and proficient as we do for our deputies, it's important to have that pay compensation there as well. And to provide, again, that local flexibility for the county commissioners through the budgetary process, through the public hearing process, through the public comment and public input to be able to set the wage for those elected officials. So I appreciate the discussion. I hope you've been able to garner facts and an understanding of the complexity of what appears to be a fairly simple issue, but on one hand and complex on the other. And if you have questions that we can assist you through this deliberation of setting that range for local control, be happy to help in the process. Mr. Chairman.
Questions for Mr. Odekoven? Okay, thank you, Mr. Odekoven, for your testimony. We'll move to Ms. Muir.
Good morning, Chairman Cookbride, Co-Chairman Nethercott. I hope I'm being heard. I see some smiles. Great. Committee, my name's Tara Muir. I'm the Public Policy Director with the Wyoming Coalition Against Domestic Violence and Sexual Assault. We want to very much support whatever mechanisms there need to be to provide not only justified salaries for sheriffs in our state, but also the attorneys you've been talking about this morning. But we just want to raise, and not take much time at all, but just raise the issues and concerns about not just the salary, but the availability of an investment in quality training and awareness about what kind of best practices we also need in Wyoming, especially around the crimes of sexual assault. In my written input through the form yesterday, I gave you all the statistics of the last 5 years of sexual assault in our state from 2015 through 2019. We've seen a steady increase of people reporting sexual assault, and we were on a bit of a good trend to make sure we had more cases clear law enforcement. And part of that definition of clearing is referring to prosecution. But what happened last year in 2019 is we had a record number of sexual assaults, 275, but only 20% of those were cleared, 1 in 4. And I know it's been a long conversation with everyone on this committee about what do we do about sexual assault. And I included in those comments as well, and perhaps for future meetings, to talk about how few of those sexual assault reports are false, which seems to be sort of the myth surrounding those cases. But bottom line is to really justify and do good work with victims of sexual assault, we need the best trained law enforcement and prosecutors and an understanding about a community response around this crime. It's just not let's pay victims a little bit of compensation and be done with it. Let's get justice. And what does justice look like for those victims? Happy to take any questions. Thank you for your time this morning.
Thank you, Ms. Muir. Any questions? Okay, seeing no further questions, Ms. Muir, thank you for your testimony. So let's move to Representative Gray. He wanted to ask Mr. Riemann another question.
Thank you, Mr. Chairman, Mr. Riemann. So this question is really pertaining to the DA county attorney issue. So we've heard a lot, the discussion of local control, which is a very popular phrase, but oftentimes isn't used, in my opinion, appropriately in the context of policy in the Wyoming legislature. And I think this is another example. You see here again that the state is paying 50% of the salaries of the county attorneys and the DAs. So to say this is flexibility to open up this cap, I think is really problematic. And I understand the answer might be that, well, the state hasn't opened up local tax revenues, but we've seen this last session that in fact, now we've opened up the 6% to be used for any discretionary expenditure. The 5% is still allowed for that. And now we have this municipal 7%. And yet we're not rolling back all of these areas over time. In fact, we're rolling forward. If you look at some of the other bills, which actually came out of this committee, in terms of the state taking on local control aspects and deciding to pay for them. And I think it's a very troubling trend. So I just ask that, just make that comment and ask if you have any response. Appreciate your work, but that's my observation in 4 years here. Thank you.
Mr. Riemann?
Thank you, Mr. Chairman and Representative Gray. I really appreciate the question. I think it's a good one to have in this particular instance. And I don't think that we're asking for all of the control to be at the county level in this conversation. This is a dialogue about what the state sees as a maximum level for these salaries, in particular, as you mentioned, the attorney salaries. What is that appropriate maximum that the counties can work within? And we currently have that statutory framework, and the commissioners are working within that particular range. You mentioned the flexibility that's been afforded. Really, there's been no additional flexibility offered to counties as it relates to any of the taxing provisions at this point in time. The changes that did take place were to afford more flexibility to the municipalities in relationship to the optional tax that was passed this past year. I also think this conversation is important for us to be having collectively, because the attorneys have a responsibility to the state and to prosecution of injuries that occur in our communities. So that is perhaps, I believe, the reason that there is that sharing of costs related to that particular set of positions. It's not just about carrying out county demands and what commissioners or others might like to see, but also what the state has put forward there. And I'm certainly cognizant, and I think commissioners are very aware of this revenue issue that we all have right now. It's not just the state. The local governments are going to be experiencing tremendous losses. So I'm not envisioning a scenario where the commissioners are running straight to the top of any pay scale that we ultimately agree on here. We're just asking for some consideration that we've perhaps hit the top of where we should be right now, and let's do that collectively.
Thank you, Mr. Riemann. Representative Gray?
Thank you, Mr. Chairman. So, Mr. Riemann, I just want to clarify here, the bill that passed, I know it failed once in the Senate and they brought it back, allowed for discretionary uses on the 6%, right? So to say that there's been no changes on local tax control in this last session, I don't agree with. Do you agree with that?
Mr. Riemann?
Mr. Chairman, Representative Gray, there's no additional flexibility. The counties can certainly take to the voters specific projects that are ultimately determined there, and that power has existed for years. So I guess I may have missed what changes happened there. There really is none. The only other change that I'm aware of that existed relative to counties was the bill that corporations brought forward relative to county reserve accounts, which did provide the ability to go to the voters with a specific project and add on that there would be some reserve that could be used for, say, let's say a recreation center could be used to help fund the maintenance and ongoing costs associated with that. That's really the only additional flexibility that was provided, but that has to go to the voters for approval for those specific projects.
Okay, thank you. Committee, I don't see any other questions for the witnesses, so why don't we move to a committee discussion of what we want to do with these bills? Is there any discussion or comments or interest in moving these ideas forward in the form of a bill draft?
Move the bill.
Moved by Burlingame. Is that a second by Pelkey?
What are we moving? Point of order, Mr. Chairman.
Let's hear from Burlingame, Representative Burlingame, what she's moving.
Thank you, Mr. Chairman. I move that the Joint Judiciary Committee draft a bill to address the salary caps.
Madam Co-Chairman.
Mr. Co-Chairman, thank you. I would ask Representative Burlingame if she would consider this a friendly amendment, that the motion to direct LSO to do a bill draft based on the recommendation from Ms. Weissman from Teton County with the following changes: that it is not a shall, but it is a may, that the maximum salary may be consistent with that of a district court judge, and then a further provision that there'll be no additional state funds to be used, but the counties certainly have that flexibility to fund that difference, whatever that might be. So 3 concepts there: to increase the salary limitation, to be consistent with district court judges, which is permissive, not mandatory, and the source of that funding for the increase in salary not be from the state.
I consider those friendly. Do you want me to restate it, or do we have that, Mary Beth?
Representative Burlingame, I'll bet she has it. If she doesn't, she can ask us for more clarification. Representative Pelkey, you're good with that as your second? Okay, we have moved to Representative Stith.
Mr. Chairman, I just have a question about the amendment that was just discussed. Is with respect to the state's contribution, is the amendment that the state would still be contributing its current level, that is half of 100,000, or is the amendment that the state's contribution will cease altogether?
Madam Co-Chairman.
Mr. Co-Chairman, it remains the same. We don't want to do 3 steps backwards here for the purpose of this bill draft. And so the 50,000 contribution that the state is contributing to that maximum 100,000 should remain the same, but no additional expenditures from the state will be utilized.
We had a comment from Mr. Fuller, and then I see Representative Pennell's hand.
Yeah, Mr. Chairman, Chairman Nethercott, I think the only question I would have is, are these changes, I know these changes are intended for county attorneys. Are they also anticipated to apply for district attorneys?
Madam Co-Chairman.
I will add that as part of the motion and then leave that up to the committee.
Mr. Chairman, still friendly.
Okay, thank you, Representative Burlingame. Representative Pennell.
Thank you, Mr. Chairman. That was my question, is who was going to pay the additional fee to district attorneys, if that was going to be the state that was going to have to come up with that, or if it's going to come back to the county commissioners to increase that. So that's kind of my question, because I'm curious where that money is going to come from.
Madam Co-Chairman.
Thank you, Mr. Co-Chairman. Maybe I'm mistaken, but I thought all of the funding for the district attorney came from the state. Mr. Fuller, can you clarify that?
Mr. Fuller?
Chairman Nethercott, that's correct. The district attorney's budget is state funded.
So that would remain the same. But obviously the state would pay so the application of the difference in the funding to the counties would not change. If we increase the salaries for district attorneys, obviously that's going to increase the state's funds because that's the sole source of funds. So I don't want to overcomplicate this amendment. Mr. Fuller, if you could come back on screen and maybe just give me a head nod to make sure you understand this. Okay.
Okay, we have a motion. We have a second. Is there any further discussion about what's being proposed? If Representative Stith?
Well, and Mr. Chairman, if it's appropriate, just to express an opinion on the motion, I'm against it. I think this is just the wrong time to be increasing salaries for government officials anywhere. We have 15% unemployment. To suggest that you can't recruit a deputy county attorney, I think is not, unless you pay them more than $100,000. In 22 of our 23 counties, that would just not be true. Teton County might be different, but they already can and do pay $140,000 a year to their deputies, apparently. And so there's a sacrifice that the county attorney in Teton County makes for her public service. But I think to change the whole state law to take care of one county's problem, it's just not a problem in Sweetwater County. I just don't see it. I don't look. I'm pretty familiar with the private sector in Sweetwater County, and private lawyers aren't making $100 grand a year. They're just not. And so I think given that we're looking at this revenue cliff, I think it sends the wrong message to be increasing salary maximums. We have a constitutional duty to set the salaries for county officers, and I just think there couldn't be a worse time, I think, for this proposal. So I'm a no.
Representative Washington.
Thank you, Mr. Chairman. I think we need to do something. I like the idea of career succession, that a deputy could become the elected, but if they have to take a $40,000 pay cut to become the elected, how many of those folks are going to be interested in a position? That said, when I use the inflation calculator, $100,000 in 2011 is worth about $114,000 today. And so to suddenly bump this up to the level of the district court judge salaries, which we just increased last year, to me seems probably excessive.
I saw Representative Jennings and then Senator Von Flatern. So Representative Jennings.
Thank you, Mr. Chairman. Had a little technical difficulty there and it kicked me off for some unknown reason. So if I could hear the motion again, I'm probably a no on it because I just don't know how we explain that to our constituents, that while their unemployment's going up and their wages are going down, that we're going to up more public expenditures. But I would like to hear the motion again. Sorry about the technical difficulty.
Mr. Chairman?
Representative Burlingame.
The motion was to consider the salary cap. It was to adopt the Teton County's language that we say that the counties may, not shall, raise the salaries, that no additional state funds would be used. And then there was something about increasing to be in line with the district court judges as well. Somebody can clean that up for me. I would just reiterate that it stays at the discretion of the counties. Nobody will have to do it. And everyone could certainly take, the point that now is not the time and leave it as it would. Or their county could have a different financial outlook than others and they could take advantage of it. That there is no shall in it, it's all may.
Senator Von Flatern.
Thank you. My county is one of the counties that probably pays a little more for the deputy than they do for the electeds. And so I'm all in agreement with this, especially since it says may, and they may raise it, and the state doesn't put any more money in it, which is one reason I would have voted against this if the state had to still honor the 50% of the increase. So I'm on and for this amendment.
Representative Gray.
Thank you, Mr. Chairman. I'm opposed to this, and I do want to clarify on the DA, the state would be paying that difference, as we talked about a little earlier. Thank you.
Representative Pelkey.
Thank you, Mr. Chairman. I seconded this motion largely so that we as a committee can explore the issue a little bit more carefully. I have to agree with Representative Stith that this is a bad time to be talking about raising salaries with state or county funds. I don't mind leaving that decision to a county if they feel comfortable enough paying a salary. But I want to explore the issue a little bit more carefully. I'll be a yes vote on this today, but there's a very good chance I'll vote no on it next time we take a look at a full bill draft.
Senator Cost.
Thank you. My concern is again with the district attorneys, and bumping that up to the 160 would be a considerable jump in their salary, and that would be a definite hit to the state. So I'm real concerned about that. I'm okay with the counties being able to make that decision on their own if they want to raise those salaries, because that's their choice. That's okay. I really believe in local control, but we lose that with the other. And I don't see us in a position where we can seriously look at that right now.
Mr. Co-Chairman.
Madam Co-Chairman.
Thank you. Just to kind of reframe the conversation, that really the motion is for a bill draft so we can have something to look at, review, and discuss, and then decide to move it forward. So I do want to refrain from having a wholehearted substantive decision on the topic. In an effort to be consistent with the purpose of raising the county attorney salaries, which is what the request is, and kind of on a effort to provide a clarifying piece on the district attorneys, which wasn't my additional motion, but just to bring it into the conversation. But I certainly don't want the issue of two salaries in the state, because there's only two district attorneys in the entire state, to kill the topic for the other 23 counties. I would withdraw that particular portion of my friendly amendment, and again, go back and make sure that that's consistent. It really wasn't my intention. It just was to really kind of bring all of the issues to light for the committee to review with the bill draft. So I will withdraw the portion as it relates to increasing the district attorney salaries, and keep it focused on those county attorneys as we've previously discussed.
And Madam Co-Chairman, there was no mention of sheriffs in your motion.
I'll refer to Representative Burlingame, but I would add the sheriffs in there as well, and look forward to the discussion on that. Maybe we can reframe our motion again.
Sheriffs, Representative Burlingame.
Friendly.
Any further discussion? Senator Anselmi Dalton.
Thank you, Mr. Chair. The one thing, if we do proceed with this, which I again have, I just have concerns. I don't think it's the right time. I've cut expenses. I'm a business that's struggling, and I just think it sends the wrong message to our people out there. But if we are going to go forward, I'd like to know how much in health benefits, how much they pay in retirement for all of these individuals. I want to see the full. This is an expensive thing. I pay $24,000 a year personally myself to Blue Cross Blue Shield to pay for my own health insurance. These people, that's a good deal. I mean, I should try to get a county job or government job, because it's a killer. That 24 grand is no small chunk of change. And, these are benefits they should appreciate and be aware of. And those costs go up every year too for Blue Cross Blue Shield. And as you get older, it goes up higher and higher as well. So I just want us to see what kind of benefits and all that stuff that's there. If they're paying retirement, if they're paying pensions, I would like to see the whole list.
Representative Pennell.
Thank you, Mr. Chairman. Yeah, I believe, obviously, I think the county attorneys and their staff to draw more competent people in needs a pay increase, but timing's everything. And as we heard from the prosecutor out of Teton County, that this probably wouldn't take effect. I mean, it would be down the road and clear up into the late 20s, 27 or somewhere in there. So I think that we probably, I'd love to give everybody a raise, but I know I can't, and I'm pretty sure the commissioners won't. And I think that that this particular bill that we probably wouldn't pass. So I'm going to be a no vote right up front. So I think timing's everything, and this is bad timing. Thank you.
Representative Washit.
Thank you, Mr. Chairman. I just don't think we ought to put the LSO staff into writing a bill draft if their sense of the committee is that we're going to not be supportive of this idea. I think that there needs to be an increase in the cap. Now may not be the time. I think that the cap needs to be increased for both the sheriffs and the prosecutors. I think it's ridiculous that your deputies are making, half again as much as the prosecutor, at least in one county, but are all pressing because why would they take a pay cut to become the elected? And we need that succession of experience and skill. But I think the 160,000 figure is excessive, and I'll be a no vote on this proposed amendment.
Madam Co-Chairman.
Thank you, Mr. Co-Chairman. I would just like to bring the committee back to the fact that this was a decision that the committee made to make as an interim topic to discuss. So I think I hear the rationale of not wanting to waste LSO's time with the bill draft. I don't think it's particularly complex bill draft. And I do think for the stakeholders who have asked for this to be an interim topic and the Judiciary Committee who identified it as an interim topic to be considered, to perhaps give it more review than the hour and to recognize that as the proposed bill draft indicates, it wouldn't take effect until a minimum 2023, so that none of the current officials who are currently in office would receive that. And so there is the level of that particular opportunity for those elected officials to take place. And it is also in the messaging and the managing. That bill draft would absolutely not give a raise to anyone by the legislature. It simply would give more power to the local officials to determine if that's what's in their county's best interest as a result of an economic recession and the increase in crime that will no doubt result. So there is logical ways through it that makes sense, and to recognize that you're not voting for a salary increase. One, that's a fallacy. Two, I think LSO's time is done. We did make a commitment to review this as an interim topic and not kill it within an hour and a half of our very first committee meeting. But again, I'll leave that to the committee's discretion. If you feel like the appearance of even discussing compensation is inappropriate right now, then that's your prerogative. But remember, we're just having a conversation. We're not giving a salary increase. And I do think that the strain on prosecutors, mental health prosecutors, and law enforcement will continue to increase. And so giving them this flexibility to make those determinations on their own, I think is prudent. But
I could see passing this motion to create the draft and raising the caps. I'm not sure I'm comfortable with the level that is being suggested for the caps. I think that's something we could haggle out at future meetings if we find there is support for the bill. So that would be my approach. Representative Burlingame.
Thank you, Mr. Chairman. I just want to echo what the good chair of the Senate just said, and remind folks that, the things that you can hang your hat on is that this is us giving local control, back to the communities where this is happening. And I foresee a real variety of responses to it. I think we heard from some folks from communities around the state. They don't have the same issues in every county. I don't think they'll have the same response to this. And I think that it's something that we have pretty widespread agreement on, that we believe in local control, and we believe that something that fits Teton County is not going to fit Sweetwater County. And this pushes back to them the ability to make the decisions for their community. And I also just want to note that, of course, the optic is terrible, saying we're looking at, raising money, in a sector, even if the legislature itself is not, actively doing that the optic is there. But I think that's why we're on judiciary. And I think that, the moment that we are in right now is not going to be the same moment in 2023. And like many of our folks in law enforcement, have noted, there is this strain that is happening right now because of the moment that we are in, that does call for greater resources, that we want to support the law enforcement, the prosecutors, the folks who are helping to keep this crisis moment in check, to keep the rule of law going steadily and strong, and that we can vote today to move it forward. And if it turns out that the moment is still not there, then we'll vote it down. But I'm just asking folks for a little forbearance, that the moment that we're in right now is not going to be where we are in 2023, is not going to be in 2024, when this is really coming into effect. So I just ask you to help vote it along.
Representative Pennell.
Thank you, Mr. Chairman. I guess my one question, I mean, we could hold this off another year, and still, if we brought it back next year, that would still give those opportunities for folks running for election in the 2023, I mean, where they would assume office. They could get the, that increase in the salary on that date or on that time frame, if my understanding is correct. And by then we can see what the state of affairs, the nation, and how things are going. I think, as I said, timing's everything. And I think this particular time is not a good time to bring that up, as we well know, of the unemployment and things throughout the state, and the revenue that's coming in to the counties, and that includes the county I'm in. I mean, the revenue is down substantially. So here again, I'm in favor of giving local control, but I think the appearance of this is just not the right time. So I think we have plenty of time to discuss this in the future, but right now, this year is not the time. Thank you.
Senator Cost.
Thank you, Mr. Chairman. To go ahead and move this along with just the local control, I'm very comfortable with. We could certainly change that upper amount from 160 down to 140 or whatever we felt would be reasonable for the counties. But even at that, this is about the counties being able to make that decision, not us. And by us taking it away, we're totally taking it away from the counties. They have the ability to look at what they're doing and say, we can't afford it, we're sorry, but that's the way it is. And maybe that gives some flexibility to some of them that can afford it. Maybe Gillette has some funding that's going to work in their favor. I'm a little questionable with the coal and all, but nonetheless, their control. So I'm in favor of carrying it along for now.
Representative Washit.
Call for the question.
Question has been called for. All in favor of the motion requesting LSO to prepare a bill draft, as we have been discussing here in the last 10 or 15 minutes, to advance the idea of raising the cap for county attorneys and for sheriffs. All in favor of that motion, would you please raise your hand and keep it raised for a time? All opposed, please raise your hand. I may not have seen all the hands. I saw a vote of 4 to 5. Could we do that again? All in favor, please raise your hands. I see 6 in favor. Correct? All those opposed, please raise your hands. I see 7 opposed. The motion is defeated. That concludes our deliberations on that topic for this morning. Why don't we take a break till 11 o'clock and then we'll pick up with our Title 25 statute discussion. And maybe Mary Beth can admit some of the witnesses to the room while we're taking the break. So break till 11 o'clock. Thank you.
Hello.
$11 o'clock, so we'll resume our meeting. Folks, I think this is going pretty well, other than the fact that the space bar has betrayed me a couple of times, but mostly it's gone well. So smile and enjoy it. We're discussing some important material, and we have some of the good citizens from all over the state with us this morning. It's a good day to be on the committee. We'll resume our meeting. Folks, I think this is going pretty well. The fact that the space bar has betrayed me a couple of times.
And Mr. Chairman, sorry to interrupt, but for everyone who was just admitted into the meeting room, if you could turn off your YouTube stream to avoid that feedback coming through, that would be great. Thank you.
And I'll wait just a couple moments until we get the rest of the guests into the meeting. Mary Beth, I don't see that everyone's here. Are they still in process, or are they on another screen that I'm not accessing?
Mr. Chairman, I believe I'm admitting them and there is a little bit of a delay. So you might want to slide your screen over to page 2.
And Mr. Chairman, to help with that, if everyone who is not speaking, who is on the agenda would turn their camera off, that would help with ensuring that Chairman Kirkbride, that you can see the legislators all on that first page.
Madam Co-Chairman?
Yes. Mr. Co-Chairman?
I just saw that you were unmuted. I thought maybe you wanted to say something.
No, I'm sorry. I think that must have happened by mistake.
Well, let's get started. We're picking up with our 10 a.m. review of the Title 25 statutes. And we have new guests in the room. And what I told the first round of witnesses, folks, was that even though it's a virtual meeting, we're still introducing ourselves and telling of our affiliation when we first come to speak. We're still going through the chairman when we testify or respond to questions. As just been noted, if you're not speaking, if you could blacken your screen, so those stand by, so you're there when we need you. And I've asked people to be promptly efficient with the time as we work our way through the big agenda during the day. So having said all that, this topic came to us from Mr. Boley in the Wyoming Hospital Association. So we'll ask him to kind of set the table for us, then we'll get into our testimony.
So I don't know if you like the participant view.
Good morning, Mr. Chairman, Co-Chairman Nethercott, committee members, Eric Boley with the Wyoming Hospital Association. The Title 25 is, as I described to you during the interim topic committee meeting at the legislative session, is a big issue that we've been facing and dealing with for years. And there are obviously a lot of issues that surround Title 25. I kind of got pulled into this. Well, let me just step back for just a few minutes because I want to save most of the time for those that have more expertise in this. But there's a long history with Title 25. I've been in healthcare now in the state for 25 years. We've been trying to figure out the best way to deal with Title 25 patients. About 3 years ago, there was a task force that was put together, and there was some legislation that was passed addressing Title 25. We didn't really take a very close look at statutes at that time, but there were some new programs that were initiated, one including a gatekeeper program. I would say that we've probably had limited success with some of those things that happen, but we've also continued to have issues that surround Title 25, who's responsible for what, how things are handled in one county versus how things are handled in another county. And so last fall, I was invited to a meeting at Wyoming Behavioral Institute, and we had a large contingency of Natrona County legislators there that listened to some of the issues that were going on. At the time, the county attorney for Natrona County was there, and we identified that there were some issues on how things are handled differently in different counties, who's responsible for payment for what particular parts of the care were one of the things that were identified. We actually garnered quite a bit of support from those Natrona County legislators, and there was even a thought of running a bill during this last session to address one small part of the problem. But then we also found out that there was work that was taking place all around the state with other county attorneys and with the County Attorney Association. So we reached out, and I know there was some work going on up in Sheridan along with the legislature there. And so then I got in contact with Mr. Beaver, who will also be testifying today. And so instead of running what we thought was kind of a Band-Aid bill during the session, we thought it made sense to take a comprehensive look at the statutes. And so since this topic was accepted by your committee, I've since been in contact with several of the county attorneys and realized that they actually had a task force that was working on this. And they've come up with a list of items that they think need to be addressed and need to be fixed. And I guess what I would say is 3 years ago when the task force met, like I said, the statutes really weren't looked at. It was more from the care side of things and the cost side of things that was looked at, but not really from the administrative side of things. And so my attempt to bring this before your committee this year is I think until we can get the statutory side of things and have that part of it taken care of, I'm not really sure how efficient or how effective the program can run if we're not on the same page in every single county. And so with that said, that's kind of the introduction. And there are experts that can talk to you about the statutes. We provided you with a list of some of the topics that we think need to be addressed during the interim. And I know you're going to receive a lot of testimony from the county attorneys on this. And I'll tell you, Title 25 is kind of a controversial topic. The one thing that did happen during the task force a few years ago is that we actually saw a decrease, not really in demand, but in providers of care for those that need mental and behavioral health assistance. And so we've actually seen a decrease in certain ways in the cost of this care, but I actually think we have some undertreated patients out there that really need help. And I think as we see the fallout and the problems that we're going to see from coronavirus, from the COVID cases, we're seeing an uptick in mental and behavioral health issues and sickness and behaviors. And so I think that the timing might actually be a little bit late, but I think the timing is good right now to take a look at this and see if there are some ways we can fix this system or shore it up to solidify statute so that all of our providers around the state know the best way to care for these patients. And with that, I'd answer any questions.
Any question for Mr. Bowley? Okay, seeing none, thanks for that introduction, and we'll move to Mr. Beaver and hear what he has to say as he represents the task force. Senator Von Flater, did you have something first?
No, I was pointing out Representative Stith.
Representative Stith, excuse me.
Mr. Chairman, thank you. Mr. Bowley, maybe I'm getting ahead of myself, but could you just kind of walk us through how the current system works, say, taking us through an individual who's on the street and police officer comes up to him and the person says, oh, I want to harm myself or others. And so then the police officer takes him to the hospital, and then there's a Title 25 hearing. Can you kind of walk us through how how someone gets committed under Title 25 and who pays for what at each stage? Because that's the payment for the first 72 hours versus payment for the rest of it is an issue that I'm fuzzy about. Thank you.
Mr. Bowley, do you want to handle that?
Mr. Chairman, I'll give it a try. If not, I'm sure that that Mr. Beaver or some of the others can correct me if I get this wrong. But Representative Stith, so we have an individual that is a threat to himself or others that's taken basically into custody. They're brought into normally the emergency room of a hospital. They're held there until there can be a hearing. The first 72 hours, my understanding, the responsibility is for the county, and after that, it's for the state. At some point, there is a hearing that is held where it is determined whether or not that patient should be admitted. And then at that point, there's a process of trying to place that patient in an appropriate setting, whether it's a state hospital or a lot of times it ends up being WBI. A lot of times there's no access because the rooms are full. So those patients will sit in a hospital that's really not equipped to care for those types of patients. And then there are questions. A lot of the hearings actually sometimes take place, I believe, in Natrona County once the patient is transported to WBI. And that's one of the good questions I think that you ask, and I think that we can address through this is whose responsibility for the transportation of that patient to and from the facility, who's responsible for the clothing if they come with no clothing. There's still a lot of unknowns out there, and that I think that's one of the areas that we really want to address as we work our way through this process. I hope that answers your question.
Okay, Senator Anselmi Dalton.
Thank you, Mr. Chairman. Mr. Bowley, thank you for that information. What I understand, and I think this is the issue, obviously, is that there's the acute care hospitals end up housing these patients for too long, and then they have to add security, and then the people aren't getting psychiatric treatment, and a lot of them are semi-homeless, as my understanding, and chronically mentally ill. And I know that in Casper, there's a clubhouse model, but how many people probably do you think are in Casper now residing in, say, the hospital instead of getting out to the needed beds in the psychiatric treatment wards? Are there, do you know the number, and have you had the hospital discuss that with you? And I'm not even sure here in Sweetwater County, I should try to call our person as well, but do you have any idea of those numbers?
Mr. Bowley?
Mr. Chairman, Senator Anselmi Dalton, that's a really good question, and it varies. Every day is different, but I would tell you, it was ironic, but a couple of years ago when all of this new legislation was passing through, when we were putting the gatekeeper in place, at that point, right here in the capital city, at our hospital, there were 18 of their 40 emergency room beds that were filled with Title 25 patients that were awaiting hearing. And there were actual patients that needed emergency that were being diverted. In some of our small hospitals, you address the situation really accurately. We're not equipped in some of our critical access hospitals. We don't have rooms that are equipped to take care of patients that could harm themselves or others. So we have to bring in additional staff. Sometimes we have to rely on the police force to come in, which they don't really want to do. A lot of times these patients actually end up sitting in jail cells as opposed to receiving that treatment. And with what's been going on at the state hospital, access there has been difficult. WBI has been full. We've actually seen other facilities that have closed down because of some of the new requirements around literature. There, as you're aware, there have been some patients that have harmed themselves still when they've been in custody of facilities that were supposed to care for them. And so it's just a problem that continues to grow, and access to care becomes harder and harder, and it puts a burden on the system.
Thank you, Mr. Boley. I think that catches us up. So now let's go to Mr. Beaver and Sheridan. Welcome, sir.
Thank you, Mr. Chairman, Madam Co-Chairman, members of the committee. My name's Clint Beaver. I'm a deputy county attorney for civil matters in Sheridan County. I do work daily with the Title 25 cases in our county. I'm speaking with you today as a representative of the Wyoming County and Prosecuting Attorneys Association. The matter of Title 25 is of great interest to our association because we do work daily with it. The term Title 25, first of all, has become a shorthand reference for Chapter 10 of Title 25 of the Wyoming statutes, and it sets forth the legal process and also the payment responsibilities with regard to treatment for the involuntary hospitalization of mentally ill individuals. There are many different stakeholders with many different perspectives on Title 25. The one consensus view among all those stakeholders is that it badly is in need of improvement. The specific problems with Title 25 depend on what aspect of the law you're dealing with. Title 25 affects, and I hope I haven't left anybody out, law enforcement, emergency medical services, local hospitals, psychiatric hospitals, community mental health centers, the state hospital, the State Department of Health, county commissioners, the district courts, the attorney general, county attorneys, patients' attorneys, and most importantly, the patients and their families. That's quite a broad spectrum of stakeholders, and it makes the discussion of Title 25 as we come to the legislature a very broad discussion. Depending on one's viewpoint, Title 25 could be viewed as a service capacity problem. It can be viewed as a fiscal problem, a logistical problem, and a legal problem. I've provided the committee with a list of several technical issues that we face as county attorneys with the statutes as they are currently written. That list comes from the working group that Mr. Boley made reference to a minute ago. Our association, we believe, has the broadest perspective of all stakeholders on the issue of Title 25 reform. As county attorneys, we're affected by all of the different aspects that I've listed. We are in regular conversation with most of the stakeholders that also deal with Title 25. Thus, we would like to be a driver in finding ways to improve the legal issues present in Title 25, working with this committee. Our association has been developing a comprehensive proposed legislation, and we would like the opportunity to share that proposal with this committee at your August interim committee meeting. Thank you very much.
Thank you, Mr. Beaver. Questions? for the county attorney, for the deputy county attorney? Anything, committee? Okay, thanks, sir.
Thank you.
We have Mr. Worrell from Worland.
Mr. Chairman, sorry to interrupt. I believe Representative Pennell may have had a question.
Did he? Okay, I'm sorry. Characters keep moving a bit on the screen. I'm not picking them up every time. Representative Pennell.
Thank you, Mr. Chairman. And thank you, Mr. Beaver, for coming. And I know Title 25 has been an issue for years. Do you have some ideas on a statute though? What because it seems to me it's all about the money. Who's paying for what? Because that first 72 hours, we know the county comes out of the county attorney's budget, from what I understand. And sometimes those costs, it depends on what location or what contracts might be involved with local hospitals or with WBI. Do you have some ideas on what would be a good plan, I guess, to get into statute? I know there's a lot of ideas out there, but reading these issues here, I don't see anything for a plan. Thank you.
Mr. Beaver.
Chairman, Representative Pennell, yeah, the list that I put in front of you would be the more technical aspects that are very important to address. And I think Mr. Woolley made the same point. When the focus is all about the money, as you've pointed out, what gets lost in that is everything else that's not the money. And that's why we're here before the Judiciary Committee. Want to support your efforts. My understanding is in the past, primarily the Health and Labor Committee has dealt with Title 25 issues and has looked at the issues primarily in terms of money and programming. We'd like to broaden the discussion beyond just money and programming and look at the nuts and bolts of the legislation.
Madam Co-Chairman.
Thank you, Mr. Co-Chairman. I understand. Thank you, Mr. Beaver, for being here. I understand that there's a working group of attorneys. Can you identify the size of that working group and generally the locations? Are you interested in having any Judiciary Committee member participation on some of those meetings? And what exactly do you hope to present to us at our August meeting? I just want to urge swift and effective work here in light of the challenges that we're going to face this next session and our work in the interim. So I want to make sure that we're doing everything as efficiently as possible. And so if you could speak to those pieces, thank you.
Mr. Beaver.
Thank you, Mr. Chairman. I like your characterization of swift and effective because I agree that's exactly what's called for. In terms of the working group, we have my colleagues in Fremont County and Natrona County. Mr. Worrell is going to talk to you in a few minutes, has also been heavily involved in our discussions. And of course, Peggy Trent is our president. The production of legislation coming from an association will be a complex effort because in 23 counties, there are very different viewpoints, and we'll have to work hard to develop a consensus within the association. But I would mention that like I'm in contact with the CEO of our local hospital, discussing their concerns. We are plugged into other groups, other interested folks in this subject matter. We're not in an ivory tower working on this legislation.
Madam Co-Chairman.
Thank you, Mr. Co-Chairman. Thank you, Mr. Beaver. I understand that it's difficult to get consensus There are 90 legislators, however, and we do big things in a very short time period. So you need to get it done. I also believe that you know exactly what needs to be changed as a matter of working those statutes and the technical detail of which is required. So I think I would ask that you just have one of these Zoom meetings as quickly as possible and painstakingly work through those statutes and really identify those technical issues that are most troubling and difficult to overcome, like the 72-hour piece. I mean, that really doesn't require massive stakeholder involvement, but when somebody goes in on the weekend, but maybe just more practical solutions from those of you working the issue on the ground. And so at least give us something to sink our teeth into and to discuss. And then maybe some of those more policy-oriented questions or harder topics for you to get consensus on because it requires larger stakeholder involvement, such as cooperation with the hospitals, et cetera. That's where we can jump in and help really guide those conversations. But the technical machinations of a Title 25 process, I know you know what you want fixed. And so I would just ask that you be more deliberate in your intentions to bring that forward so we can work through it.
Mr. Beaver?
Thank you very much for that encouragement.
Any Representative Jennings?
Thank you, Mr. Chairman. And I guess mine is both to Mr. Beaver and the co-chair also. Is this a topic that's large enough that that maybe it needs broke down into 2 or 3 areas so that we don't try and eat the entire elephant at once, but on the other hand, we can put it into, we don't necessarily lose the entire thing at once either. As I look through it, it seems like there's a lot of moving parts to this. There's a lot of things that we might be able to touch and make some real changes to have a real impact. And so as I looked at it, I thought, boy, if we try and tackle this whole subject with one piece of legislation, I'm not sure it'll fit on our desk. And so I'm just asking the co-chair and Mr. Beaver, either one, is this something that we might break into a couple of 2 or 3 pieces that might make more sense to do it that way? Thank you, Mr. Chairman.
Well put, Representative Jennings. I'd had some of those thoughts myself. See if anyone has a response to that. Madam Co-Chairman.
Thank you, Mr. Co-Chairman. To respond to that, that's my strong message to the county attorneys, that in order for us to take this in the scope of which is requested, I think, is a complete review of Title 25. It will require the committee to have full-on assistance from those prosecutors, those county attorneys who are tasked with doing these civil commitments. And quite frankly, just from my perspective, strong suggestion as to what it is you want. I know there's always this resistance of we're not the policymaker. It's your job as legislators to decide, here's the problem, go solve it. But in light of the scope of this situation and our kind of lack of understanding of what it looks like on the ground, for many of us, I believe it will be necessary in order for us to tackle this in the way that you want to with the time that we have available, for you to provide and come out of your comfort zone, maybe very specific recommendations for what you think would work best, as opposed to kind of identifying the problem for us and then leaving it to the committee to solve it. So that would be my suggestion, and that's the only way we'll be able to manage this.
Good. Representative Washington.
Thank you, Mr. Chairman. Mr. Beaver, I would also add to that the more specific you are, the better. But if there are, a handful of issues, 1 or 2 issues where there is a divergence of opinion within the county attorneys, if you could give us option A and option B and let us make the tough call between those, at least we're moving forward with the limited range of options that we can then make decisions about.
Thank you, Representative. Senator Cost.
Thank you, Mr. Co-Chairman. this is kind of a passionate of being a president of the hospital board in PAL, and also having a number of meetings with the county attorney and the sheriff's office and the hospitals in both PAL and Cody. Boy, there's some real difficult sides to this that really makes it hard, especially when there's no availability in Evanston or Casper to send these people. And so they're held in the sheriff's office, in the jail. And of course, there's a potential for suicide. So then you have to have them in a room that is not welcoming to anybody by any means. So they're deprived even more. And then the other side of it is the funding does come into issue, because after the amount of time that they're held in the hospital, that needs to be collected. And for that to be paid in a long distance period of time rather than in a more readily available becomes a real issue too. So there's a lot of strings attached to this. I know there's not any easy answers. We've been able to make headway here to where things are getting better, but still the delay going to the institutes such as Casper or Evanston is a real problem right now, and nobody's equipped to be able to take care of these people locally.
I don't see anything else from the committee. So thank you, Mr. Beaver, for now. We might now go to Mr. Worrell and hear his take. Mr. Worrell.
Thank you, Mr. Chairman, Madam Co-Chairman, representatives. I'm supposed to start my video, so I just will do that. My topic is somewhat more limited. Madam Co-Chair, maybe I can get to some of the detail about at least one aspect of this problem that you would like to hear addressed, and I'll do my best to do that. I got interested in this when I saw the interim topic. I follow you all pretty closely, and I get stuff on my email all the time. I look at it. When I saw the topic that talked about the idea of county attorneys misconstruing certain aspects of what were and were not costs in this matter, and sort of an ad hoc approach to the payment of same, I made a couple of inquiries to an earlier witness about this, and then the next thing I know, I'll get invited here. So thank you. I appreciate it. I do have some thoughts on this. I sent along a list of topics that are much broader than we have time to cover here today. Those were sort of my stream of consciousness thoughts about how I would best go about addressing this. If somebody has a question about one of the things on my list, I'll be glad to address it. However, I'm going to try to limit this mostly to the concept of cost. If you look at the statute to begin with, well, that series of statute, 2510, 101, etc. You're going to see a fairly consistent broad brush definition of what costs are, but nothing that really gets down into the details of what those things are and when and how that's supposed to take place. There was an earlier discussion about how Title 25s are initiated, and very commonly they're not initiated by law enforcement, although that does happen and it's permitted by statute. Most of the time, the people walk into the ER and they're in distress or whatever, and the local mental health authority is called. They come over, make an assessment, and then it starts there. Many counties, that happens all at the hospital. The only place available to house these people is either the hospital or a jail. Or if you're in one of the larger counties, maybe in a mental health facility such as WPI. We have something different here. You're going to hear from one of my county commissioners later about, listen carefully, because it's an option that you may wish to consider in this big picture. Nonetheless, the meter starts ticking when someone is taken into custody. And the first 72 hours of that, plus weekends, plus holidays, which usually seems to add up to 5, but I guess conceivably could be 6 days, but it's more likely 5. That responsibility for this mysterious cost is with the counties. The counties pay that money, and I don't believe my budget has that in it. The county has that budget. I do approve all of those bills ultimately. There's also a provision in 2510-104, what is it, A7, for the creation of rules. And there are some rules. But what they address is the department's responsibilities. They address nothing about the county's responsibilities. So how these costs get handled by various counties is usually dealt with by the county attorneys. Now, when we're put in that position, our counties are probably every bit as crushed from a budget standpoint as the state is, maybe more so. Now, more than any time since I can recall that since I've been a lawyer, which is 1979. Our job is to look out for our counties. So what do? We do what lawyers do. We look for holes in the law. We look for ways to negotiate payments with various providers. And we drive a hard bargain if we can, if we have leverage, if there's something that's not covered or whatever it might be. Yes, we do that. We do our job for our counties. So I'm not really here to defend every county attorney in the state. There's 23 of us that make these decisions. But it is what we do. And if you want to correct some of this stuff, I'm certainly sympathetic with what Mr. Boley had to say. So hospitals end up hanging out on these things. Others do too. What is needed, in my estimation, is a consistent definition of exactly what costs are. Every one of them. What are they? What are supposed to be paid for as part of this? Transportation, a stay in the hospital, what kind of medical care? And there's some distinction there. It has to be related to the mental illness that's being complained of, or the reasons why a person was taken into custody, they cut their wrists or something like that. Certainly those are going to be paid for by the counties in that first 72-hour period, plus. Taking it a little farther though, if you look at the rules, the Department of Health has developed an entire series of rates that they have, and they set ceilings on those. They're usually tied to Medicare or Medicaid, depending on the circumstances. But if you also look at those rules, I appended a copy to my materials. There's nothing in there that addresses the county's responsibilities, although it's supposed to be by statute. No one's ever created those rules. Those would be very helpful if we all knew what the rules were. It would take a lot of the lawyering out of it for myself and my compatriots, if you will, because we know what we'd be able to clearly assess what's there. By establishing rates, as the state does for its reimbursement of providers, then we have some cost protections built into what we might end up having. With no rules or regulations that govern what those costs might have a ceiling on, we find ourselves hard pressed to come up on occasion with the monies to pay various providers. It's simply an economic consideration. It's an equation that is a budgetary consideration, much like you're going to deal with in the current session or the COVID session, the special one, and then this coming session with this shortfall and all kinds of revenue that the state's always had and never will again, maybe. So what we need is consistency in a thorough, and I stress thorough, definition of what these costs might be. That would require input from all of the providers, the hospitals, the mental health providers, the appointed counsel. Maybe we should set a rate on that like they do for workers' comp attorneys or whatever it might be. For the hearing officers, if they do them like they do in Casper, I think they have a magistrate that does those. And whatever else there might be. Transportation costs are huge. If you look at the back end of this thing, somebody gets out of a treatment facility, either the state hospital or WBI or elsewhere. It's really unclear who pays the cost to get them home. It says the county has to make arrangements for them to get to another place. And that's a paraphrase, but it's pretty close. It's not clear. This can be done better. And it's a starting point, and it only addresses the monetary aspects. I believe there's a question. Mr. Co-Chairman, I don't believe your microphone's on there.
Representative Washington.
Thank you, Mr. Chairman. Mr. Worrell, I appreciate you being here today. Could you maybe address how frequently it is that these Title 25 patients have underlying medical conditions that also need to be attended to when they're at the hospital, and how those costs are presently dealt with?
I'll try, yes. I would say probably 75% of the time they have pre-existing conditions that may or may not be related to their mental illness. But when they show up and they have them, clearly they have to be treated. The statute does draw this distinction as far as who's responsible for those costs, and the counties or whoever is not responsible for anything that's not directly resulting from the illness. Now, people that, as a group of people, the folks that have mental health problems, you can't really define where they're going to come from. It could be any one of us, but more often you're going to see a higher percentage of people that suffer from alcoholism. Maybe they're lower income, homeless sometimes, depending on the location. Cheyenne probably has a lot of those people living under the interstate, whatever it might be. But they come in with all kinds of things that are really difficult to ascertain. Good example right now, someone comes into a mental health facility, and this has been a problem with WDI. What if they have the COVID virus? Who pays for that? That's not resulting from their mental illness, or is it? It depends on how that gets diagnosed, you know. I guess my point is that there is a distinction. I do think that there's a lot of these costs that come with these people that right now the statute doesn't say they should be covered. Maybe that's part of the overhaul. I don't know how the counties are going to afford to pay their share of it, depending on what it might be. But I'm not going to say that it shouldn't be something that's considered, or maybe if the rates are set such, it would be more manageable from a monetary standpoint. And I'm speaking for the counties now, but also for the state. I hope that answers your questions. Okay.
Any other questions for the attorney? All right, Mr. Worrell, thank you very much. Madam Co-Chairman.
Senator Lisa Anselmi Dalton has a question.
Senator Anselmi Dalton.
Thank you, Mr. Chairman. And I'm not sure this is for the attorney necessarily, or maybe it's for Mr. Beavers. I'm not as familiar with Title 25 as some. Doesn't it, I wonder which hospitals are hit the hardest by this Title 25 payments. Is my county, Sweetwater County, taking a big hit because it has a hospital here, or other counties not taking such a hit? And should this be a state obligation versus a county obligation is what I don't know if we know those numbers. Do you know those?
The numbers, what are these again, ma'am?
Mr. Chairman. Thank you. Mr. Worrell, the amount, which hospitals take the hardest hit for housing these Title 25 patients? I mean, it's got to be expensive in some cases when someone perhaps tries to kill themselves or something happens and then they have to hold them for 3 days. Is Sweetwater taking a harder hit than other counties, I guess?
That is going to vary from county to county. We have a facility here that is much less expensive than staying in the hospitals, and it works for most people. You're going to hear about that from Commissioner Anderson later today. I really would urge you to talk to him about that because it works very well for us. That's not why I'm here, so I'm trying to stay clear. That would be the main thing I was going to say.
Madam Co-Chairman.
Thank you, Mr. Co-Chairman. Just real briefly, Mr. Worrell, can you help explain to the committee and maybe the public who decides if an individual needs to be taken into custody for that first 72 hours? Who are the decision makers at that level?
Okay, that's a really good question. The first person that can decide that is a member of law enforcement. That is one method by which, and it's all instituted with what's called the Form 381. And it's a very short document. It has the time they're taken into custody, the reasons, some of the things that presented with the people. Law enforcement can do that. More often, at least here, more often, the person that does do that is a mental health professional. They will come over from our local mental health facility or anyone elsewhere, and they make the decision to actually take the person into custody, an emergency hold, it's called. And then the next step, and you heard a little bit about this, the next step would be a temporary hold, which has to happen within the 72 hours, weekends and holidays excluded. So the decisions to do that are either mental health professionals or law enforcement, sometimes a combination of both. They make the decision to do the hold. Does that help?
Madam Co-Chairman?
Okay.
Representative Stiff.
Yes, Mr. Chairman, and this is for Mr. Worrell or any of the other witnesses. My anecdotal experience is I've got a couple clients who tend to be frequent flyers in the Title 25 program. They've been committed 6, 7, 8, 9 times. It's just they're consuming a lot of resources. Is there anything practical that the legislature could do to alleviate that?
Mr. Worrell.
You're asking me that question. I appreciate that. I guess I'll take a whack at it. Probably the short answer is no. If people are deciding to be frequent flyers in the mental health system, they're going to be. And if the threshold for getting into the mental health system is changed, in other words, the definition is currently a person is a danger, by reason of mental illness that's diagnosable, is a danger to themselves or to others. The frequent flyers, in my experience, tend to be more people that suffer from methamphetamine psychosis or something like that. The ones that are the alcoholism, the ones that are there repeatedly. That's a mental disease as well. It has a lot of other aspects to it, but I guess in some ways that has to be done. One thing that can be done to eliminate some of the expenses already on the books, it's a directed outpatient commitment. Those are hopefully going to be used more frequently, and I'm way afield from why I'm here. But I would personally like to see those used much more often and more effectively. I think the state and the counties would save a lot of money. There would be more bed space available for folks that really needed it. I hope that helps.
Committee, anything else? Mr. Worrell, Representative Burlingame.
Thank you, Mr. Chairman. Thank you, Mr. Worrell. Do you happen to have statistics handy about how many of those involuntary commitments are of minors and how many are of adults? And if you don't have the statistics, that's fine. It's just a question I had. But I was wondering, in that intake process, what does it look like if the parent isn't on board with that evaluation? Who has precedence then?
Mr. Worrell?
And you're talking now about juveniles, correct? We don't have a lot of those here. We've used mental health proceedings on occasion to deal with juveniles. One of the factors that we find is that most of the facilities that are available to take care of folks like that don't take care of juveniles. I believe, I can be corrected on this, but I believe WBI is currently the only facility in the state that will actually take a juvenile into custody pending the resolution of the Title 25 situation. Now, as the temporary custody hearing, this Representative Burlingame, this hopefully will address your question. If a parent disagrees, for example, with a diagnosis from the local mental health authority, they certainly are able to bring their own person and have their own examination conducted. I personally insist that we have 2 conducted, one at the intake and one prior to the hearing, because a lot of times people's condition will change fairly dramatically once the crisis passes. So and commonly that's a solution for these local crisis stabilization centers, is it allows people to resolve their mental health problems in the short term without having to go all the way through the process. So, but anybody that feels that a diagnosis is inaccurate is certainly able to present their own. Counsel is always appointed for a person that's subject to a title. Their counsel can acquire an expert if need be at the cost of the county, but they can do it. And they can put forth the interest of that person much more effectively if that's something that a parent, for example, or the child would desire to do. One aspect of the crisis stabilization centers that's useful is that we don't have the limitations on the ability to take minor minors into those facilities because they're all kept separate anyway. So we could do that.
I think we're caught up, Mr. Worrell. Thank you.
Okay.
Let's move to Mr. Johansson.
Thank you, Chairman Kirkbride.
I hope I'm pronouncing that right. And I'll tell you, Mr. Johansson, we're going to go to noon, and then we'll take a 45-minute lunch break. So that may interrupt you in the middle of your testimony, and I'm sorry, but that's kind of the time schedule I want to propose. So please continue.
Chairman Kirkbride, thank you. I'll try to be brief in my comments. And members of the committee, I'm Stephen Johansson, the Deputy Director for the Wyoming Department of Health. I oversee most of the department's operations and support functions, as well as directly supervise and oversee the Wyoming State Hospital. So this topic is not only near and dear to my heart, but quite a bit of experience with Title 25 over the past 6 or 7 years. I was asked today to speak really on 4 broad topics, and most of the topics that I'll speak about, I think, will benefit from the testimony that preceded me. I think I'll be able to answer some of the questions that came up, at least from the Department of Health's perspective. Those 4 areas that I've been asked to talk about are the financial responsibility under Title 25 between the state and the counties, the Department of Health's reimbursement process for Title 25, various opportunities, both statutory and programmatic, for Title 25 services and Title 25 policy. And last but not least, as time allows, prepared a bit of data update from the Department of Health's perspective to address some of the questions that I heard this morning surrounding volume of Title 25 costs, things of that nature. I did prepare a brief presentation for you all. You should have it. Looks like this. So I'll just walk through that briefly. On slide number 3 with financial responsibility, to elaborate on what some of the preceding witnesses mentioned, the Title 25 commitment process, and I will dramatically oversimplify this, is really 3-pronged. And that involves the emergency detention, a continued detention, and an involuntary hospitalization proceeding. And all of those have their own legal mechanisms, their own policy issues. But just from a general perspective, there's basically 3 steps. As was mentioned, folks are generally either encountered by law enforcement or brought or go into an emergency room or a healthcare setting, and that emergency detention, depending on their symptoms that they present with, can be initiated. That essentially generates a 24-hour hold before an initial hearing has to be conducted. Once that hearing is conducted and potentially the court says that this person is mentally ill, dangerous to self or others, then a continued detention under subsection 109 of the statute can be initiated. That's a detention for up to 10 days, including weekends and holidays. And again, that's under section 109. Finally, the involuntary hospitalization hearing can be held. That's governed under section 110 of your statute. And that's where the court ultimately decides if a patient, if a person is civilly committed to the custody of the state hospital or per the new statutes that were put in place a couple of years ago, the court can elect to involuntarily outpatient commit a Title 25 patient to outpatient services. The Department of Health really begins its interaction in the system in steps 2 or 3, or B and C, as it says on your presentation, and that's because of that 72-hour rule when it comes to the cost for Title 25. So that brings me to the topic here of financial responsibility, which is governed by subsection 112 of the Title 25 statute. And what everybody talks about is the first 72 hours versus the post 72 hours. That's the easiest cut point, where the county, as folks will say, is responsible for the first 72 hours of cost of a Title 25 proceeding, and the state is responsible for the anything after 72 hours. So if you think of those 3 steps, that post 72-hour period is pretty usually, generally speaking, in the continued detention and involuntary hospitalization process. Now, it gets a little bit more complicated, as many of you know, probably in more detail and more experience than I do, when it comes to county of resident versus county of detention. In subsection A of 112, you'll see subject to language, and that always gets a little bit complicated and tricky in statute. But basically it says subject to provisions D and E, the county of detention should pay all cost in the first 72 hours of the Title 25. So then you have to reference D and E, and in fact, subsection E says that if someone is detained under section 109, which is that continued detention, then the county of residence should pay the first 72 hours of Title 25 proceedings. So it's a bit clumsy in the reading of it, but if you try to read into the intent from the legislative perspective, which I'll try to do at my own peril, I think what it was intended to do is really say for a 24-hour hold for an emergency detention, the financial responsibility in that first couple of hours or first day should really be the county that detains a person. Now, if the hearing moves on and someone is ultimately held for a continued detention based on their symptoms of mental illness, then it appears the legislative intent is to have the first 72 hours paid by the county of residence. So that's, again, has been complicated ever since I've been involved in Title 25. And I think what Mr. Boley, Mr. Worrell were referring to when it comes to the confusion on who pays cost at the county level is really subsumed within those two sections. But that's my, again, my amateur reading, not an attorney, but my amateur reading of the legal intent behind section 112. So again, it really comes down to you have an emergency detention, a continued detention, and potentially an involuntary hospitalization. And in that first 72-hour period, that's how we in the Department of Health read the county financial responsibility. Ultimately, if we have individuals who are detained under Title 25 who are not residents of the state of Wyoming, then the Department of Health is responsible for all of those Title 25 costs. Moving on, Mr. Chairman, to slide number 4 in the presentation here. Just really briefly, I don't want to stand between the committee and lunch, so I'll try to wrap up quickly here. The Department of Health, in reimbursing for those post 72-hour costs, we did back in 2016 implement a new claims processing system for Title 25 that's really much more efficient. It's rules based. Some of the folks preceding me mentioned some of our rules for reimbursement, but essentially we either pay on a per diem at $677 per day for a designated hospital like WBI. That's for folks who are awaiting admission to the state hospital. We pay that $677 per day plus any professional fees unless the client is Medicaid eligible, and then the system allows us to determine if they're Medicaid eligible, Medicare eligible, sometimes if they have private insurance, and we can route those costs appropriately. So we've been able since 2016 to run all these claims through the Medicaid system, pay based on those rules, not pay for services rendered in the first 72 hours. And most importantly, from my perspective, we've been able to collect much more longitudinal data on our Title 25 population, especially in that post 72-hour period, by nature of running it through a much more technical and computerized claims processing system. So moving on, Mr. Chairman, to some of the opportunities on slide 5. I will mention, based on some of the comments that were made before about the wait list, both at the state hospital and sometimes at WBI, we are optimistic that this is going to be dramatically improved over the next year with the construction projects and renovations that are happening both at the campus in Evanston as well as the Wyoming Life Resource Center in Lander. We anticipate really starting this summer, when we start moving into the new state hospital in Evanston, increased capacity just by nature of the physical plant improvements. And then about a year later, about a year from now, when the Life Resource Center is completed, there will be a new skilled nursing facility on that campus, partially intended for some of the long-term care patients, elderly geriatric psych patients that are at the state hospital currently with no place to go, that will be better served in a skilled nursing setting setting in Lander. So over the next year, we should see some dramatic improvements in our capacity in the Title 25 system. And I know some folks are skeptical about that, but I'm very optimistic that not only will our capacity, our wait list, and our cost improve, but I think the service delivery for the patients will be much higher quality, and the wait time for our county partners, for our attorneys, for our hospitals should be alleviated. Secondly, Mr. Chairman, I would mention there is a provision in statute that's been kind of the burr in the bonnet, so to speak, of a lot of county attorneys, and well-intentioned, but I think operationally naive. Under Section 112, little h, there is a 24-hour reporting requirement for county attorneys. Basically, when anything happens in Title 25, an emergency detention, a continued detention, an involuntary hospitalization, counties are required by statute to report that to the department within 24 hours. Again, well-intentioned, data flowing in always makes sense to make good policy and good treatment decisions, but operationally, again, a bit naive in counties being able to not only do that, but the department doesn't standardize that data. We did create a website for county attorneys to report into, and they do report into it periodically, but it's not data that's very standardized. It's not something that we're acting on within that 24-hour period. I think that could be something where the state and the counties agree that could be either removed from statute or at least reconsidered over the interim period and leading into the next session. So, Mr. Chairman, I'll stop there. I did provide some data updates so that the committee could see both our involuntary hospitalizations by year, by county, our projected state costs, as well as kind of a visual depiction of our wait list at the state hospital, as well as some of our short-term and long-term patient volume. But in the interest of time, I'll stop there, see if there are any questions, and appreciate the time, Mr. Chairman and Madam Co-Chair.
Thank you, Mr. Johansson. Committee, we could take a question or two if it doesn't get too involved. Otherwise, we might break for lunch, but I see Representative Pelkey with his hand up.
Thank you, Mr. Chairman. Somewhat taken aback by that characterization of the 24-hour reporting period as naive. Rather than the disparaging characterization of that requirement, could you please go into detail why that is ineffective?
Mr. Chairman, Representative Pelkey, that's a great question. I certainly didn't intend to sound disparaging, but I do think that again, the reason I think it's less useful or less utility with that data is particularly related to the kind of bifurcation of the systems. The Department of Health does not control the first 72 hours of Title 25. And so by nature of that, we don't control the data definitions when attorneys might file or choose not to file a 381 form, a continued detention or not. It's really not something that we control and standardize. After the first 72 hours is really when the department takes over with rules and policy. The second reason, Representative Pelkey, that I would mention that is less effective is just the inconsistency of county reporting. And again, that's no insult to our partners in the county attorney's office. It's just a reality that sometimes I receive spreadsheets on a monthly basis from counties with their Title 25 data, which is not, the 24-hour compliance there. And sometimes there's counties, smaller counties that do enter that data pretty timely, some that batch it. So again, it's a bit inconsistent. And I think that's something that could be revisited with the utility of what data should be flowing from the counties to the state and how potentially we could partner together, especially in light of our claims system, where maybe over the coming years, we could leverage some efficiency between the department and the counties when it comes to claims processing and data reporting. Thank you.
Representative Pelkey.
Thanks, I appreciate it, Mr. Chairman. I'm a little concerned. I mean, I think if you perhaps consider going back to the original motivation behind the 24-hour reporting requirement, maybe there's a way that we can change statute to make that reporting more consistent. What I'm concerned about is, we have civil rights issues. We have mental health issues that we're facing. And I think the fact that we can get data to your department and to others as quickly as possible might actually help some of those folks in being released from a mental health hold or getting proper treatment sooner. And I'm just wondering, and again, I don't mean to give you a hard time about the disparaging remark that it was naive, but if you understand what the motivation was behind that initial requirement, how can we address that rather than simply abandoning it?
Mr. Chairman, if I may, Representative Pelkey, again, I think we're in total agreement on the concept here when it comes to reporting or data about the patients from the counties to the state. I think instead of just getting rid of the concept altogether, I think there's other areas of the statute, for example, the gatekeeper statutes that were put into place where that's really a local entity that, a community mental health center or a provider that would be in partnership with the department and the counties and the courts doing that case management, doing that situational awareness where, the patients are known about and the resources are hopefully being managed there. So again, I think we're on the same page in concept. I just think that requirement specifically could be revisited with county attorneys, potentially having to dedicate staff to a data reporting requirement that might be less useful.
Representative Pelkey.
Yeah, I appreciate that answer. I think it's a little more thoughtful than simply abandoning the whole concept. So, yeah, I mean, I'm a big fan of the gatekeeper concept since we've been doing that in Albany County now for a few years, and it seems to be working rather well.
Anything else from Mr. Johansson? Any other questions, committee? All right, sir, thank you for your testimony. Let's take a break until 12:50 for lunch, and then we'll come back with Ms. Hendricks and a couple other witnesses on this subject. So, Mr. Johansson?
Mr. Chairman, I did want to introduce the committee to Jerry Hendricks. She's our policy administrator for the Department of Health. There's no need for additional presentation from the Department of Health unless there are questions. So we're happy to listen in after you break for lunch, but we have no additional information to present unless the committee has questions for us.
Okay, then we'll consider you'll be around for a resource when we meet again at 12:50. Thank you.
Mr. Chairman, Ms. Hendricks will be around. I will not be. I have a meeting with the governor's office. My hair tends to catch on fire with COVID-19 response these days. So, but Ms. Hendricks is more than willing to stay around.
Okay, thank you very much. Thank you for your work on COVID-19. And Ms. Hendricks, we might be talking to you after the break. So thanks for being here. Okay, committee, let's break until 12:50. Turn your cameras off if you would.